Good morning, ladies and gentlemen. We are about to start the proceedings here at this very first international research conference being held here in Sri Lanka in law, the EdHat International Research Conference in Law 2023, proudly hosted by IDM Nations Campus, under the theme, ladies and gentlemen, Knowledge of Law for everyone. At the very outset, I would like to call upon the members of the head table to come near your respective seating areas. Can we have our chief guest grace in this occasion, His Excellency Mr. Tariq Mohammed Ariful Islam, the High Commissioner of Bangladesh here in Sri Lanka, the Conference Chair, Professor Wasantha Seneviratne, guest of honor, Chair Professor, Department of Public and International Law, Director, Center of Studies on Human Rights and University of Colombo, Sri Lanka, Mr. Orlando Edwards, Country Director, the British Council, Sri Lanka, Senior Professor, Dr. Rohana P. Mahalinarachi, the Conference Chair, Dr. Janagan Vinayamurthy, Director, International of EdHat International and Chairman of IDM Nation Campus International, Mr. Alan Clark, Chief Academic Affairs of the EdHat International UK, Ms. Alison Madden, Associate Professor, Head of Partnerships, Business and Law, Buckinghamshire New University UK, Dr. Lionel Pinto, Honorary President, IDM Nations Campus International, Sri Lanka. At the same time, we'd like to tender a very special warm welcome to Dr. Venkat Iyer, Barrister and Legal Academic, UK, Director of Educational Partnerships, International Affairs, School of Law, University of Ulster, UK, Mr. Portner, Lecturer, Academic Employee Representative, Dr. Bhavana, School of Law, Upadhya, University of Delhi, Mr. Prasantha Lal Dialvis, President's Council, Mr. Mohammed Faizer Mustafa, President's Council, Dr. Ernest Fahim, Pakistan Bar Council, Pakistan, and Mr. Sri Haran of EdHat. So, ladies and gentlemen, this is the very first EdHat International Research Conference in Law 2023, being conducted here on the theme Knowledge of Law for Everyone. And we have the partners, the Buckinghamshire New University UK, University of Ulster UK, and it is being proudly hosted by the IDM Nations Campus International, Sri Lanka. EdHat International, as you're aware, is one of the leading UK-based education service organizations providing quality academic and institution-related services for individuals and organizations who are aspiring to lead. Developed in accordance with the British standards, EdHat International Service meets the changing needs in a wide variety of sectors and career choices of young people all over the world. And ladies and gentlemen, today we're at this first ever EdHat International Research Conference in Law 2023. Apart from the inaugural session where you are attending currently, we'll be having the paper presentations and the launch of the EdHat Law magazine, where the theme would be rights and wrongs, plus the closing ceremony with special recognition of awards being presented. To welcome all of you for this gathering, it gives me great pleasure to call upon a very special personality. Ladies and gentlemen, a highly accomplished professional with a diverse educational background and extensive experience in the field of education, holds a doctorate in business administration from the Lincoln University in Malaysia, which he pursued from 2016 to 19. Prior to this, he completed LLB degree from the University of Buckinghamshire in the UK. Ladies and gentlemen, also possesses an MBA in Energy Management from the University of Wales in the UK, which he earned in the year 2011. His graduate studies include BCom Special in Management from the University of Colombo, Sri Lanka, where he graduated in the year 2006. In terms of professional memberships, he is a fellowship member of the British Computer Society, FBCS, in the UK, and a member of the Association of Business Executives, and a member of the Institute of Electrical and Electronics Engineering in the US, also a member of the Institute of Directors. Additionally, has achieved various professional qualifications past finalist of the Chartered Institute of Management Accountants, CMA in the UK, and holds Cisco Certified Network Associate certification. Since 2002, he has been serving as CEO of IDM Nations Campus Sri Lanka Private Limited, an innovative higher education institute in Sri Lanka, and under his leadership, the institute has gained recognition for offering nationally and internationally recognized programs to students. Furthermore, he has obtained partnerships with reputed organizations, enabling students to avail discounts on their purchases. Ladies and gentlemen, his impressive academic achievements, professional memberships, qualifications, and CEO role reflect his commitment to education and leadership in the field of higher education. Please welcome Director, International EdHat International UK, Dr. Janagan Venagamurthy to come on.
Ladies and gentlemen, good morning and warm welcome to EdHat International Law Conference 2023. It is an absolute pleasure to see you such a distinguished gathering of legal professionals, scholars, enthusiasts, and students under one roof. Your presence here today signifies your commitment to pursuit of justice and the advancement of the legal field of world. Before we proceed, let me take a moment to express my heartfelt gratitude to each and everyone over here for grasping the function in front of you all. Your participation and support have made this gathering truly meaningful, and we are honored to have you here. I would like to extend my warm welcome to our chief guest, His Excellency Mr. Tariq Muhammad Ariful Islam, the High Commissioner of Bangladesh to Sri Lanka. Sir, you have taken a step forward to give your valuable time scheduled to join with us. Your presence not only adds a prestige to this event, but also serves as inspiration for each and every people gathered over here. And we are very proud to welcome our esteemed guest of honors. Here we have three guest of honors. I have to name it: Professor Wasantha Seneviratne and Ondalo Edwards. Ondalo Edwards is a country director of British Council, as well as our partner from our partner university, Buckinghamshire University, the chief academic, associate professor of head of partnership, business and law, Mrs. Alison Moulton. So you guys, you are creating a valuable time with us. Definitely, it's going to be a marvelous time. And this particular time, what we are going to spend here, I feel all our students and the presenters, as well as the participants, they will definitely take it as meaningful. It will be a great pleasure to have you all here at this 2023 conference. This conference stands as a testament to our shared belief that legal education and understanding should be accessible and accessible to all. It is an opportunity for us to come together, learn from each and everybody, and explore ways of make the legal knowledge more inclusive and readily available to each and every people in the world. This conference serves as a platform for us to come together, exchange ideas, and it will be when we go for exchange idea, we can have a lot of critical differentiations. We can got a chance to discuss about that, and that can be shape our society. We are privileged to have some of the brightest minds in the legal professionals with us today. I am confident the discussion and the interactions over the next few hours will be truly enlightening. The field of law, the place in indispensable role in our life. It provides the foundation for justice, upholding the principle of equality and fairness, and safeguards the rights and freedom of each and every individual. It's through the rule of law that we ensure the just and harmonious society. In today, the complex and rapidly changing world, the legal provisions faces numerous challenges. Technology advancements, globalization, and involving society and required for certain and continued changes, and we should adapt and find innovative solutions. This conference serves as a platform for us to collectively address these challenges, to share our experience and explore new perspective and approaches. Throughout this conference, we have an exceptional lineup of esteemed speakers and experts in their respective field who will be sharing their insights and research and their own experience. I would like to express my heartfelt gratitude to the organizing committee and the conference chair, Professor Rohana Maharaji, and all the staff who have spent their time and with tireless to bring this conference in front of you without any hesitation. Their dedication and hard work have ensured that we have well-structured and engaging program that cater to the diverse interest and need of the attendees over here. All the participants, I encourage you to actively participate in this session, ask questions and engage meaningful dialogues. This conference is not just a passive learning. It is about collaboration, networking and building connections that will lasting impact on your academic and professional career. Finally, once again, I would like to welcome each and every one of you being over here today. Your presence demonstrates your commitment to staying abreast of the at least development in the legal field and your dedications and upholding principles of justice. Your contributions and the insights are invaluable, and together we can strive for more equitable and just society. I wish all enriching and fruitful experience at the EdHat International Conference 2023. May the discussions and the deliberations here inspire us to make positive difference in the world. Thank you, and let the conference begin.
Thank you very much, Director International, EdHat International UK, and CEO of IDM Nations Campus International, Dr. Seneviratne. Welcoming all of you. Next, I would like to call upon the conference chair for the opening remarks. I would like to call upon Senior Professor Rohana P. Maharaji, who is an esteemed and accomplished personality with an impressive array of qualifications, experiences, and achievements. He possesses a diverse educational background, including an MSc in Agricultural Engineering from Agricultural University in Bulgaria, a PhD from the Postgraduate Institute of Agriculture, University of Bhavan in Sri Lanka, and an LLB from Buckinghamshire University, UK. And he has also completed a prestigious postdoctorate fellowship at the University of Reading, UK. Ladies and gentlemen, please welcome the conference chairperson and editor-in-chief, Senior Professor Rohana P. Maharaji.
Very good morning. Ayubowan, Vanakkam, Suprabhata. The Chief Guest, the High Commissioner of Bangladesh, Mr. Tariq Muhammad Aliful Islam. The keynote speaker, Professor Wasantha Seneviratne. Distinguished guests, learned paper presenters, esteemed participants, ladies and gentlemen. It is my distinct honor and privileged to extend a warm welcome to all of you gathered here today for the EdHat International Research Conference in Law 2023. As we embark on this intellectual journey together, I am filled with a sense of enthusiasm and anticipation for the enriching discussions, groundbreaking research, and meaningful connections that lie ahead. I would like to extend my deepest thanks to Mr. Tariq Muhammad Ariful Islam for accepting my invitation to be the chief guest of this conference. Further, my next thanks goes to Professor Wasantha Seneviratne being accepting the invitation to be the keynote speaker of this conference. The field of law plays a pivotal role in shaping our societies, ensuring justice and safeguarding the fundamental principles that underpin our democratic systems. It is through rigorous research, analysis, and critical thinking that we can navigate the complexities and challenges of the legal landscape. This conference serves as a testament to our collective commitment to advancing legal scholarship and fostering an environment of knowledge sharing and collaboration. The theme of this conference is an essential topic that affects each and every one of us, the knowledge of law for everyone. In an increasingly complex and interconnected world, understanding the basics of law has become not only beneficial but also necessary for individuals from all walks of life. As we gather here at this research conference, it is crucial to recognize the role of law in shaping our societies, promoting justice, and ensuring the protection of our rights and freedoms. Law is the cornerstone of civilization, providing a framework for resolving conflicts, upholding order, and fostering social harmony. It encompasses a broad range of areas including constitutional law, criminal law, civil law, international law, and many more. While it may seem daunting and accessible to some, the fundamental principles of law can be made accessible to everyone, enabling us to navigate the legal landscape more effectively. One of the key benefits of understanding the law is that it empowers individuals to assert their rights. We live in the world where rights and freedoms are enshrined in various legal instruments, such as national constitutions, international treaties, and regional agreements. Without knowledge of these legal protections, individuals may find themselves vulnerable and unable to defend their interests when faced with unjust treatment or violations. By educating ourselves about the law, we gain the tools to safeguard our rights and hold those in power accountable. Moreover, a basic understanding of the law promotes active citizenship and civic engagement. Democracy thrives when citizens are informed and participate in the decision-making processes that shape their communities. Whether it is through voting, advocating for policy changes, or engaging in public discourse, legal knowledge equips individuals with the capacity to contribute meaningfully to the social, economic, and political development of their societies. Additionally, understanding the law enhances our ability to identify and address social injustice. Laws can both reflect and perpetuate inequalities within our societies. By learning about the law, we become better equipped to recognize systematic bases and advocate for legal reforms that promote equality and justice for all. It enables us to engage in constructive dialogue, challenge discriminatory practices, and promote inclusivity. Furthermore, legal literacy has practical implications for our everyday lives. It helps us navigate legal systems, understand contractual agreements, and protect ourselves from potential legal pitfalls. A basic knowledge of the law empowers individuals to make informed decisions and seek legal advice when assert their rights, actively participate in democratic processes, and address social injustices. By promoting legal literacy, we can foster a culture where the law is accessible to all, regardless of their background or profession. As we continue to explore new frontiers of research and innovation, let us remember the importance of a legal framework that supports and protects the rights and freedoms of every individual. We are fortunate to have a diverse and distinguished group of scholars, practitioners, and experts from a number of countries as UK, India, UAE, Pakistan, Sri Lanka, Malaysia, who have come together to contribute their insights and expertise. Your presence here today is a testament to the significance of this conference and the recognition of the vital role that research plays in evolution of law. During the day, we will explore a wide array of topics that span the breadth and depth of the legal discipline, from constitutional law to human rights, from international law to emerging legal technologies. Our conference program encompasses a rich tapestry of ideas and perspectives. I am confident that the decisions and debates that will unfold today will shed new light on complex legal issues and inspire innovative approaches to address the challenges of our time. I would like to express my deepest appreciation to our distinguished keynote speakers, whose expertise and vision will undoubtedly provide invaluable insights and set the stage for fruitful discourse. I am also immensely grateful to the members of the organizing committee for their tireless efforts in curating a comprehensive and engaging program, ensuring a seamless experience for all participants. To the presenters, I commend your dedication, research endeavors, and commitment to pushing the boundaries of legal knowledge. Your contribution from the bedrock of this conference, I encourage you to seize this opportunity to share your findings, engage in constructive dialogue, and foster connections that will shape the future of legal scholarship. Lastly, I would like to extend my gratitude to Buckinghamshire New University and Ulster University in UK, and IDM Nations Campus, who are the partners of this conference, and our sponsors and supporters who have generously contributed to making this conference a reality. Your commitment to academic excellence and advancement of legal research is deeply appreciated. In conclusion, let us embrace this conference as a platform for intellectual exploration, collaboration, and transformation. May our deliberations be characterized by open-mindedness, respect, and the shared commitment to the pursuit of justice. I wish you all an inspiring and rewarding conference experience. Thank you. Stuti, Nandri, Dhanyavad. Wish you all a good day.
Thank you very much, ladies and gentlemen. The conference chair, Senior Professor Dr. Logonapi Mahalina Arachi, addressing all of you whilst making the opening remarks. Next, I would like to call upon one of our guests of honor to address all of you. She is the Associate Professor, Head of Partnerships, Business and Law at the Buckinghamshire University, UK. An experienced academic who possesses over 10 years of experience in education, working in both the further and higher education sectors, has allowed her to develop extensive knowledge in course design, validation, and management and quality assurance. Ladies and gentlemen, through her career, she has focused on developing, delivering, and managing various partnerships in UK and globally. Please welcome Ms. Alison Maiden, the Associate Professor, Head of Partnerships, Business and Law, Buckinghamshire University, UK.
Let's try that again. Welcome, everybody. It is my deep honour and privilege to be asked to speak here and to represent Buckinghamshire New University. Dr. Janigan's vision of making law accessible to all is more important than ever now in the world that we find ourselves in. And with his partnership through Buckinghamshire New University, you all have the privilege of studying the courses that will allow you to take activism in making this possible for those that are most vulnerable within our societies. laws are right there to protect us all, but it's all too often the most vulnerable in our societies that don't have access to the representation that they need. And through these educational partnerships and these law clinics, he's making this possible. Now, I'm going to speak directly to our wonderful students, because really and truly is why I'm here. I want to speak with you and I want to engage with you. But as an educator, I'm about to set you a task. So pens at the ready, please. I would like you to fully engage with this amazing opportunity that you've been given. Be brave, network. I'll let you into a little secret. Nobody really likes networking. We all find it a little bit intimidating. But it's how you get to know really important people within your field. Be curious. Ask lots of questions. And question the answers that you are given. And I also want you to embrace some activism. How are you going to empower others after this conference? So, I'll give you a little bit of warning. We've got our pens out, notebooks. I want you to note down 3 things that you would like to take away or achieve at this conference. Because this is going to give you a focus to come back to. And I'd like you to review it at various points throughout the day, and then also at the end of the conference. And then to think about, what did I actually take away from this? Did I achieve all of it, none of it, or a little bit? And then finally, what did you take away from today that you didn't expect to take away? And then I want you to think about how you're going to use it. So give yourself a focus, set out to achieve that focus, and then reflect on whether it happened or not. To those of you that are presenting today, thank you so much for the truly inspiring and cutting-edge topics that you have chosen to present. And I wish you the very best of luck. And I'm sure this conference will be a huge success. Thank you very much.
Thank you very much, Ms. Alison Merton, the Associate Professor, Head of Partnerships, Business and Law, Buckinghamshire University, UK. And we'd like to call upon our next guest of honor, ladies and gentlemen. Please welcome Mr. Orlando Edwards, County Director, the British Council, Sri Lanka, to address all of you.
Your Excellency, Minister, esteemed guests, ladies and gentlemen, my name is Orlando Edwards. I'm the Director of the British Council. British Council, for those of you who don't know, is the UK's international organisation for cultural and education relations, and we've been here in Sri Lanka for almost 75 years. I'm honoured and feel privileged to have been given the opportunity to address all of you this morning at this inaugural session of the EdHat International Research Conference in Law 2023. I'd like to express my gratitude to EdHat in collaboration with its partner, Iyer Nations Campus International Sri Lanka, for organising this auspicious event. Their commitment to fostering intellectual exchange and creating platforms for academic growth is admirable. As we gather here today, it is crucial to acknowledge the role of education in shaping the legal landscape. It is through comprehensive and rigorous academic programs that aspiring legal professionals can develop the skills necessary to tackle the complexities of our ever-evolving world. In this regard, I would like to highlight the significant contributions of the British Council in Sri Lanka. The British Council has been at the forefront of promoting educational collaborations between Sri Lanka and the United Kingdom, facilitating opportunities for students to pursue higher education abroad. And through supporting the growth of transnational education, also known as international partnerships here in Sri Lanka. Furthermore, the partnerships between EdHat IDM Nations Campus International Sri Lanka and Buckinghamshire New University, offering bachelor's in law and master's degrees programs, is a testament to the commitment of these esteemed institutions in providing quality legal education. By emphasising the importance of legal research, the EdHat International Research Conference in Law creates an invaluable platform for scholars, researchers and practitioners to exchange ideas and explore new boundaries in the field of law. Such endeavours contribute to the advancement of legal knowledge and pave the way for innovative approaches to address the complex challenges and issues of society today. I encourage all the participants, all of you here today, to fully engage, just as Alison said, in intellectual discussions. I've had a look at the programme, it's fascinating, some of the abstracts, so I congratulate all the students for all the abstract submissions. I'm only sorry I won't be able to stay for the whole of the duration of the event. Do take full advantage, as Alison said, of the networking opportunities and collaborations that this conference offers. It's through collective efforts and interdisciplinary approaches that we can go beyond boundaries and unlock new possibilities. Once again, I extend my thanks to EdHat and IDM Nations Campus International Sri Lanka for their unwavering commitment to education. May this conference be a catalyst for transformative ideas, inspiring us all to contribute to the betterment of our legal systems and societies. Thank you, and I wish you a fruitful, enriching and successful conference.
Thank you very much, ladies and gentlemen. The Country Director to British Council Sri Lanka, Mr. Orlando Edwards. Next, I would like to call upon our chief guest to address all of you at this inaugural session of the first ever EdHat International Conference in Law 2023. He is an experienced career diplomat who assumed his position as the High Commissioner of Bangladesh here in Sri Lanka in the year 2020. Prior to his current role, he served as the Deputy Permanent Representative at the Permanent Mission of Bangladesh to the United Nations in New York. With a career spanning over 2 decades, he joined the Bangladesh Foreign Service in 1998, has held various diplomatic assignments both domestically and globally. From 2005 to 9, he served as the first Secretary Counsel at the Permanent Mission of Bangladesh to the United Nations in New York. Also worked as the Counsel and the Bangladesh Deputy High Commissioner in Kolkata, India. Within the Ministry of Foreign Affairs of Bangladesh, he has held significant positions including Director General South Asia, Director South Asia, and also served in the Director Foreign Minister's Office, Personal Wing, and the Foreign Secretary's Office, showcasing his diverse experience and expertise. Ladies and gentlemen, please welcome the High Commissioner of Bangladesh to Sri Lanka, His Excellency Dr. Tariq Mohammed Ariful Islam, to address all of you.
Thank you for the very kind introduction. Am I audible? Senior Professor Rohana P. Mahalianarchi, the conference chairperson, Chair Professor Madam Wasantha Seneviratne, our today's keynote speaker, Ms. Alison Mayton, Orlando Edwards, and other distinguished speakers on the stage, Honorable MP, distinguished participants, ladies and gentlemen. Ayuban, Vanakkam, Assalamu alaikum, Namaskar, and a very good morning to all of you. Let me begin by thanking my good friend Dr. Rohana for inviting me to this very prestigious event. It is a distinct honor and pleasure to address this august gathering. I also thank the co-organizers for hosting this event. I think I am the least qualified person here to speak on law, since I have neither a law background nor a practice law. So I'm really nervous to speak in the company of legal experts and luminaries. In any case, as a diplomat, we have to deal with the laws of our own land, international law, and the law of the recipient country. Therefore, understanding basic laws, abiding by laws, and applying laws to our daily work is essential. Since we get the chance to see different aspects in different corners of the world, at least one thing we diplomats know is the importance of basic knowledge of law in a person's life. From these perspectives, I would like to share some of my thoughts today, which you may find very superficial though, yet I hope you will bear with me. Ladies and gentlemen, law is not only for lawyers. It affects our daily life. Law is for everyone. The importance of law in public life and in the life of each of us cannot be overemphasized. We like it or not, this is a reality. We may not understand it until we face it, and it's inevitable in some point of everybody's life. Having the basic knowledge of law is required to ensure our rights and responsibilities, safeguard us from exploitation, maintain discipline, and perform public duties. It helps us understand that laws that apply to us, whether it's traffic law or it's the tax laws. It promotes compliance within the law, ensures that we conduct our activities in a lawful manner. With legal awareness, individuals can seek appropriate remedies and enjoy the protection of law. A basic understanding of the legal system and how laws are made empower individuals to actively contribute to civic life. It promotes an informed community, strengthens democracy, and ensures that individuals can effectively participate in shaping the society. Law is the last resort when no other remedy is available. That is why the theme, knowledge of law for everyone, is very topical. However, despite all the necessities, legal domain remains somewhat weak to common people. Legal texts, their interpretations, and applicability of law are often difficult to follow and understand. Legal process, particularly in our subcontinent, is lengthy, cumbersome, and sometimes unaffordable. Abuse of the law by vested quarters and influential quarters is rampant. For all these reasons, there is apprehension about law among common people. So we need to make the law inclusive, user-friendly, and understandable to common people. They should be able to use the law to their benefit and welfare, and that should be our goal. Ladies and gentlemen, since I am from Bangladesh, let me now turn to the use of law and share our Bangladesh experience. The Constitution of Bangladesh, the supreme law of the land, guarantees the independence of judiciary as well as the judges and the magistrates. Our judiciary is the main pillar of our statehood, and it plays an important role for advancement of democracy, human rights, and rule of law. In Bangladesh, we have more than 1,000 laws, and these are enough to protect our people from injustice. But the more important thing is the applicability and the enforcement of the law. Apart from applying legal and constitutional provision, our Supreme Court, in appropriate cases, resorts to judicial activism to protect people's rights, which encompasses the areas of legislative backlog. However, our ongoing judicial backlog of court case is the biggest impediment in our judicial system. However, our ongoing judicial reform programs are expected to reduce the caseload significantly. And digitalization of judiciary is also taking place and making remarkable contribution in this regard. Bangladesh is a common law country with its legal system developed by the British during the colonial rule. We follow a dualist common law tradition, and international law needs to be incorporated and codified into our domestic legislation to give effect. Bangladeshi courts
follow the principle that codified national law will always supersede customary international law. The power to decide whether an international customary law is applicable in Bangladesh or not falls upon the Supreme Court, and the court always seeks out domestic laws on the matter of dispute first before resorting to international law. Additionally, our courts do not enforce treaty obligations even if they are signed and ratified if they do not form part of the corpus juris of the state. However, there is no bar to direct application of international law. In fact, international customary law has been recognized as enforceable in Bangladesh when it comes to fundamental global norms and if such law is not contrary to any domestic law. Thus, international law has a significant influence in the interpretation of the constitutional provisions of Bangladesh as the source of legal authority. Now, let me turn to the use of law in the public life in Bangladesh. The people of Bangladesh experience many justice needs in their daily lives. 8 out of 10 of our adult population experience one or more legal problems every year. The most common and serious legal problems are land disputes, neighbor conflicts, and crimes. Yet, only half of these people seek legal information and advice or resort to the court of law. The rest rely on alternative dispute resolution mechanisms. Lack of awareness, apprehension about the lengthy procedure, affordability, these are the major reasons behind this apathy. Therefore, ensuring access to justice is high on the agenda of our government. We have been investing heavily in this area. We have put in place the Legal Aid Services Act and implementing it. We have put, in general, our people have high level of trust and confidence in our courts, and they also enjoy a high level of legal empowerment. Ladies and gentlemen, I was also told to share a bit about our journey, our experience, our experience in dealing with international law. Bangladesh has been contributing to the development of the body of international law through its activities and value-driven engagements in multilateral discourses at the United Nations and other international organizations. And having served at the permanent mission of Bangladesh in New York twice, I have seen it myself. And I was privileged to be part of this global norm setting and law making. The contribution is towards creating normative and legal frameworks and legally binding instruments in the areas that concern developing countries. Bangladesh has been particularly vocal in areas such as climate change, migration, public health, exploration of marine resources and marine genetic resources, peacekeeping and peace building, disarmament, anti-terrorism, atrocity crimes, violence against women, and so on. And these are the very issues that also concern Sri Lanka. So on these areas, Bangladesh and Sri Lanka work very closely together at the United Nations and other international organizations, and I have seen it myself. We are also working for developing global governance structure for artificial intelligence and disruptive technologies. Also for ensuring equitable access to global public goods and developing capacity building of the developing countries. We are also contributing to the works of the multilateral legal entities like the International Criminal Court, the International Court of Justice, and the International Law Commission for legal norm setting. And we are party to most of the international treaties and conventions. Ladies and gentlemen, Bangladesh and Sri Lanka enjoy shared history, culture, and tradition. Our social norms and moral value systems are also very similar. Due to our colonial legacy, our laws and legal systems have many commonalities. Our peoples are peace-loving and law-abiding. Sri Lanka is well known in the region for its strong legal structure and high quality of its legal community. Looking at the developments in Sri Lanka over the past 2 years, I have seen it myself, the very important and commendable role the legal community here played in addressing the difficulties facing the nation. That is why experience sharing in relation to delivering justice to the people would be highly beneficial for our two countries. It is indeed happening, but we need to take it to the next level. I hope the legal communities of the two countries would step forward for more collaboration for our mutual benefit. On this note, I'd like to conclude. Thank you for your attention, and I wish the conference a grand success. Bhavana.
Thank you very much. Our chief guest gracing this occasion, ladies and gentlemen, the High Commissioner of Bangladesh to Sri Lanka, His Excellency Dr. Tariq Mohammed Ariful Islam. Next, here at this inaugural session, we are ready for the keynote address. Let me call upon Professor Wasantha Seneviratne, who is the Chair Professor of Public and International Law, attached to the Faculty of Law, University of Colombo, Sri Lanka. Served 2 terms as the head of the department until May 2023. Also, the directors of the Center for the Study of Human Rights, a research institute affiliated to the University of Colombo, has been teaching, researching and publishing in international law, human rights law and humanitarian law for the last 29 years and teaches public international law, international humanitarian law and human rights law, both at the undergraduate and postgraduate levels in many law teaching institutions in Sri Lanka. Has authored, edited and published a number of books, book chapters, research articles in local and international journals, and presented several research papers at several international and local research conferences, and conducted several research studies with local and several international partners and published them. Theories of public international law, humanitarian interventions, and use of force, concept of responsibility to protect, and its application in current situations, continued relevance of humanitarian law in post-conflict situations, transitional justice, and human rights application in armed conflicts are some of the key areas of research. Ladies and gentlemen, please welcome the Chair Professor, Department of Public and International Law, Director, Center of Studies on Human Rights, University of Colombo, Professor Wasantha Seneviratne.
Thank you very much for that very generous welcome and note of introduction. His Excellency Tariq Mohammed Ariful Islam, the High Commissioner of Bangladesh to Sri Lanka, Senior Professor Dr. Rohana Mahalenarachi, Conference Chairperson of EdHat International Conference, United Kingdom, the guests of honors and all the distinguished guests, ladies and gentlemen. I take it very much privilege and an honor for taking me to be the keynote speaker of this very reputed conference. Before I move into the formal keynote speech, the prepared one, I want to flag a couple of things. As a person, as an academic and a legal professional that has been working in the field of law and trying my level best to keep the law not only within some selected few in society, to make law as a privilege, kind of a heritage of a few, but to make the law most accessible to people in the country. In this endeavor, I have been trying, number one, to integrate law into the school curriculum. Yet it is not happening in Sri Lanka, but we have attempted to make at least law is a module taught in some of the subjects, at least below the level of ordinary level examination, and we have been partly successful because we were able to introduce law and justice and human rights as some modules in a subject called civic education. Now we are trying to lobby the governments to make the law into the A-level syllabus stream, at least the general law, to be integrated into the A-level curriculum, and thereby making people aware and knowledgeable about the law. Otherwise, I wish to mention about the character you will find in the very well known book written by Leonard Woolf, known as Village in the Jungle. There's a character called Silindu. Silindu was a poor villager, ignorant about what is happening in the world, and he did not have any idea about what the law is. But unfortunately, he happened to be a so-called alleged offender in a so-called murder happened in the village, and that he attempted to kill a person due to very humanitarian reasons, but he could not understand what was said and spoke in the courts, and finally he could not be able to plead innocence in this crime. So therefore, I think that we understand that not only the lawyers or legal academicians, law students, or other people who are working in the domain of law only should know law, but it should go to the people at large in the society that we are living. With this very small note, I wish to thank for joining me today to be the keynote speaker as we dwell into the fascinating world of law and its significance for everyone. Therefore, I would like now to focus your attention on the knowledge of law, particularly in the context of Sri Lanka as a nation with a rich legal heritage and a vibrant legal system, that Sri Lanka has been offering valuable insights into the importance of legal awareness for every citizen. However, law at its core is the foundation upon which societies are built, but provides the framework that governs our interactions, protects our rights, and upholds justice. But the true power of the law lies not only in its existence but also in the knowledge and understanding of its principles by the general public. Otherwise, that we will continue to witness the courts with Silindu and other people who are ignorant of law, and they are unable to access to law and justice, and who will be deprived of their rights. Therefore, the objectives of my keynote speech today is to emphasize the importance of legal literacy and its role in empowering individuals and communities. One of the fundamental aspects of legal knowledge is the understanding of one's rights as well as responsibilities. By knowing the laws that govern their daily lives, individuals can better navigate various situations, protect themselves from exploitation, and ensure their rights are respected and ensured. In Sri Lanka, as in any other country, the legal system encompasses a wide range of areas, including constitutional law, criminal law, civil law, human rights law, labor law, and much more, including our interactions, implementation, and incorporation of international law that create a lot of legal obligations on the part of sovereign country, and that we are under the scrutiny of international legal institutions and other communities of states when we are breaching those laws, and the benefit will not be given to the people at large. Acquiring basic knowledge in these areas enables the citizens to make informed decisions, seek legal remedies when necessary, and actively participate in the democratic process that shape their nation. We all are aware of the social contract the people and the rulers are having. So this is not somewhere documented, but a hypothetical contract that all of the contribute to the society, because that the sovereignty of a country lies in the people and which is inalienable. So they agree to delegate those authority to the rulers to a given stipulated time, and this social contract should be very well maintained and established through the legal awareness that people should have. Otherwise, that the inadequate lack of lacuna in their legal literacy will lead to lack of their political literacy as well as lack of their participation in the democratic process. Furthermore, legal knowledge is vital for promoting equality and social justice. We all are born free and equal. Therefore, right to equality is very much important. from a country like Sri Lanka, which is a multicultural society where several ethnicities, different religious groups, and different languages are spoken. Therefore, this is very much wide. Therefore, Sri Lanka, like many other countries, such as Bangladesh, as His Excellency very well stipulated, certain vulnerable groups face unique legal challenges. Women, children, persons with disabilities, and marginalized communities often encounter discrimination and violation of their rights. By understanding the law, individuals and vulnerable groups can recognize injustice and advocate for change, thereby promoting a fair and inclusive society. In this regard, legal literacy acts as a catalyst for social transformation and upholding the principles of human rights. To foster legal knowledge among the general public, it is essential to promote legal education at various levels. Educational institutions, starting from primary schools to universities, play a crucial role in shaping individuals' understanding of the law. As I already said at the outset, that we have been trying to achieve this to our country, to make the people better knowledgeable about the law. Integrating legal education into the curriculum empowers future generations with the necessary skills to become responsible and law-abiding citizens. Additionally, legal awareness campaigns, community outreach programs, and public legal clinics can bridge the gap between the legal system and the people it serves. Therefore, we have to take law from the law books and from the letters to action. That is very important, to take the law into the society and to keep them in the social context that we live. Moreover, in today's digital era, technology can significantly contribute to enhancing legal literacy. Online platforms, mobile applications, and interactive resources can provide accessible and user-friendly legal information to a wider audience. Sri Lanka, with its growing internet penetration and digital literacy rates, can influence these advancements to promote legal awareness among its citizens. While individual legal knowledge is vital, collective legal consciousness is equally crucial. It is through the collective understanding and respect for the rule of law that a society can thrive. Therefore, it is essential to foster a culture of legal awareness where discussions on legal issues, debates on legal reforms, and engagement with the legal system become commonplace. By doing so, we create a more transparent, accountable, and just society, and I think this conference is for that. And thank you very much for organizing this conference to achieve such tasks. The principle that ignorance of the law is not an excuse is a fundamental presumption in legal systems around the world, including Sri Lanka. It signifies that individuals are expected to know and abide by the law, regardless of whether they are aware of its specific provisions or not. But how the people would come to know about the law if the knowledge is not so common, and there is no platform to share the knowledge of law among the people, and therefore how that we expect them to be abide by it, that ignorance of the law is not an excuse. Therefore, as we discuss the importance of legal literacy for everyone, it becomes essential to emphasize and its implications. In a society where the rule of law prevails, individuals are presumed to have knowledge of the law. This presumption arises from the notion that the law serves as a set of rules that govern the conduct of individuals, and it is a responsibility of citizens to acquaint themselves with these rules. While it may seem like a challenging expectation, understanding the rationale behind this principle helps shed light on this significance. However, the presumption of knowledge of the law fosters a sense of personal responsibility and accountability. It encounters individuals to actively seek information about the law that govern their actions and to make informed decisions accordingly. By doing so, citizens become active participants in upholding the rule of law and ensuring the orderly functioning of society. More of this presumption acts as a deterrent against potential misconduct. If individuals were allowed to escape liability simply by claiming ignorance of the law, it would create a loophole that undermines the effectiveness of the legal system. The presumptions that everyone knows the law helps promote compliance as individuals are aware that ignorance will not serve as a valid defense in legal proceedings. However, it is crucial to acknowledge that the presumption of knowledge of the law can present challenges, especially for those who lack access to legal education or face barriers to legal information. Recognizing this, efforts to enhance legal literacy become even more critical. By promoting legal education and providing accessible resources, we can work towards bridging the gap between the expectation of knowing the law and the actual understanding of it. In this context, legal literacy initiatives play a pivotal role in equipping individuals with the necessary tools to navigate the legal landscape. They empower individuals to understand their rights, obligations, and the potential consequences of their actions. By fostering legal literacy, we not only enable individuals to fulfill their responsibilities as informed citizens, but also help to ensure that the legal system operates on the principles of fairness and justice. Therefore, it is important to note that while ignorance of the law may not excuse individuals from liability, there are instances where the law recognizes exceptions for those who genuinely lack knowledge of a particular provision. For an instance, if a law is newly enacted or recently amended, individuals may require a reasonable amount of time to familiarize themselves with the changes. However, these exceptions are generally limited, emphasizing the overarching principle that individuals are expected to have a basic understanding of the law. In essence, the principle that ignorance of the law is not an excuse underscores the importance of legal literacy for everyone. While it sets a high standard of knowledge, it serves as a reminder that individuals have a responsibility to educate themselves about the laws that govern their lives. By embracing legal literacy initiatives, we can bridge the gap between expectations and reality and empowering individuals with the knowledge they need to make informed decisions, uphold their rights, and contribute to a just and equitable society. So, moving to the end of my speech, that I wish to say, by implementing all the practical strategies, we can enhance legal literacy among the general public in Sri Lanka, and empowering individuals with legal knowledge and resources will enable them to make informed decisions, protect their rights, and actively engage in legal processes that shape their lives and society as a whole. Therefore, I really acknowledge and appreciate the endeavors taken by the organizers of the conference, including conference chair and other dignitaries, and all of you, the audience here, that we will expect a better Sri Lanka tomorrow by having legal literacy and high level of awareness among the people. Thank you very much.
Thank you very much, Professor Wasantha Seneviratne, keynote speaker, for those words of utmost expertise. Ladies and gentlemen, with that, we are ready for the introduction to the EdHat magazine in law. Would like to call upon first the Chief Academic Affairs of EdHat International UK, Mr. IRCLAW, to give an introduction to EdHat magazine in law. Then after that, we will be having the launch of the magazine.
Good morning. It's my great pleasure to introduce this new magazine, the EdHat Law Magazine, titled Rights and Wrongs, which is very apt for this conference. The magazine explores and exchanges insights on emerging legal issues and trends worldwide. In this issue, there are 23 diverse range of articles, all from legal scholars, practitioners, and professionals from various countries, including UK, Sri Lanka, and India. I've had the privilege of seeing this publication, and I would invite you all to delve into it and embark on a journey of enlightenment. The 23 articles include Benjamin Disraeli on the United Kingdom's unwritten constitution. I was not aware that we had an unwritten constitution, so I'm looking forward to reading that. Demystifying public law, the importance of legal knowledge for all. Continuing the theme that ignorance of the law is not an excuse. The next article that I chose is exactly that. Ignorance of the law is no excuse. Impact of technology on the legal profession. We're all now subject to technology and how that's going to impact the legal profession. Navigating the era of data protection. With all our information now being digitally stored, that is an important topic. And the final one that I looked at was what law is and what it ought to be. Very interesting topic. I invite you all to read this magazine. It's a very influential magazine, and it's a very easy to read magazine. When you see the magazine itself, don't be overwhelmed by it. The articles are short articles. You can read them over a coffee break, put the magazine down and come back to it later. I hope you enjoy it, and thank you for your contributions.
Thank you very much, the Chief Academic Affairs, EdHat International UK, Mr. Alan Clark. And now we'd like to call upon Dr. Janagan Vinigapurthy, along with Mr. Alan Clark, to present the first copies of the EdHat magazine Law to our chief guest, His Excellency Tariq Muhammad Ariful Islam, the High Commissioner of Bangladesh to Sri Lanka, and to our guests of honor, ladies and gentlemen. And the next copy will be presented to Ms. Alison Maiden, the Professor, Associate Professor, Head of Partnerships, Business and Law, Buckinghamshire University, UK. Mr. Orlando Edwards, Country Director to British Council, Sri Lanka. Our keynote speaker, ladies and gentlemen, Professor Wasantha Seneviratne. And we also have the conference chair being presented with the copy, Senior Professor Dr. Rohana P. Mahallinarachi. The Honorary President of IDM International University, in fact, IDM Nations Campus International, ladies and gentlemen, Dr. Lionel Pinto. We'd like to call upon Honorable Arundika Fernando joining us in the audience to receive your copy of this EdHat magazine in law as well. Honorable Buddhika Pathirana, Mr. Kamini Jayasinghe, Mr. Sriharan. Dr. Amitabh Upadhya. Professor Dr. Bhavana Maheva. Dr. Venkat Iyer. Mr. Ze'ev Portner. Dr. P. Bhavana Rao. Mr. Wasantha Lal Yalvis. Mr. Faiza Mustafa. Dr. Ernest Fahi. Right, thank you very much. Thank you very much, Mr. Alan Clark. And now, ladies and gentlemen, marking the inauguration of the EdHat International Research Conference in Law 2023, we have the presentation of mementos. Once again, we'd like to call upon Dr. Seneviratne, along with the conference chair, Senior Professor, Dr. Rohana P. Mahalina, to step forward, please. And a word on the magazine, ladies and gentlemen, it is ready for your own collection by paying 1,000 rupees at the registration desk. Presentation of tokens of appreciation. First, to our chief guest, ladies and gentlemen, one more time, His Excellency Mr. Tariq Mohammed Ariful Islam, the High Commissioner of Bangladesh to Sri Lanka. We also have our keynote speaker, Professor Wasantha Seneviratne. Mr. Alan Clark, Chief Academic Affairs at EdHat International UK. Ms. Alison Maiden, Associate Professor, Head of Partnerships, Business and Law, Buckinghamshire, New University, UK. Mr. Orlando Edwards, Country Director to British Council, Sri Lanka. We also have a special token of appreciation to Dr. Lana Pinto, President, IDM Nation Campus International, Sri Lanka. And then, ladies and gentlemen, to the conference chair, Senior Professor Dr. Rohana P. Mahalina, being presented. Chief guest will also join the dignitaries in doing the honors. And then, ladies and gentlemen, the man behind the gate, we call him none other than Mr. Janagan Vinegapurti. We also have a special token of appreciation to you, sir. Thank you very much, gentlemen. So, in wrapping up the formalities, as we're going to move on with the rest of the proceedings, it's time to say a very big thank you to certain teams, individuals, everyone who contributed towards the grand success of the first ever the EdHat International Research Conference in Law 2023. To propose the vote of thanks, we'd like to call upon the conference coordinator, EdHat International UK. Please welcome Ms. Sambhavi Arunanthi.
Honorable Chief Guest, Honorable Guest of Honors, keynote speakers, respected members of EdHat International UK, staff members of IDM Nations Campus International Sri Lanka, session chairs and organizing committee members of EdHat International Research Conference in Law 2023, dear presenters and participants. Be grateful for what you have and where you are in your journey. Gratitude is the key to manifest abundance. These words of wisdom from the inspirational speaker, Abraham Hicks, perfectly encapsulate the sentiments we feel today as we gather for the inaugural session of EdHat IRCLAW 2023. On behalf of the organizing committee, I am filled with gratitude, and it is my honor to express my heartfelt thanks to each and every one of you present here. First and foremost, we would like to extend our deepest gratitude to the Almighty God for making this international conference in law a momentous event in the history of EdHat International. This gathering not only facilitates knowledge sharing, but also builds relationships on an international scale. I would like to express our immense satisfaction and honor in having His Excellency Tariq Muhammad Ariful Islam, the High Commissioner of Bangladesh to Sri Lanka, as our esteemed chief guest. Your presence and the inauguration of IRCLAW 2023 have made great significance to this event. We are truly grateful for your inspiring compliments on this inaugural session, sir. We also extend our profound and sincere appreciation to Ms. Alison Maiden, Associate Professor and Head of Partnerships, Business and Law at Buckinghamshire University, UK, for gracing us with your presence as the guest of honor. Your insightful speech on behalf of the university has enriched our conference. We also extend our heartfelt thanks to Mr. Orlando Edwards, Country Director of the British Council Sri Lanka, for accepting our invitation to be our guest of honor. A special thank you goes to Professor Wasantha Seneviratne, Chair Professor in the Department of Public and International Law and Director of the Center of Studies and Human Rights at the University of Colombo, Sri Lanka, for delivering the keynote address. Your valuable insights and extensive experience have undoubtedly benefited us all. We sincerely appreciate your presence and contribution as a keynote speaker, ma'am. Our gratitude extends to Senior Professor Dr. Rohana P. Mahalianarachi, the conference chairperson of EdHat International UK, for his dynamic efforts in making this event an extraordinary success. We would also like to express our thanks to Dr. Janagan Vinayamurthy, Director International of EdHat International UK and Chairman of IDM Nations Campus International Sri Lanka, as well as Mr. Alan Clark, Chief Academic Affairs of EdHat International UK, for their invaluable assistance and support in organizing this conference. We would like to acknowledge and appreciate all the academicians, research scholars, paper presenters, and participants from renowned institutions worldwide who have traveled here to be a part of this conference. Your presence and contributions have made this event truly exceptional. Thank you for sharing your knowledge and expertise with us in IRCLAW 2023. I would like to also express our gratitude to all the staff members and volunteers who have worked tirelessly behind the scenes to ensure the smooth execution of this conference. Your dedication and hard work have been instrumental in its success. Lastly, I would like to thank each and every one of you present here today for making this inaugural session truly special with your presence. Your enthusiasm and support inspire us to strive for excellence in all our endeavors. We hope that the rest of today's sessions will be fruitful and enlightening for all. Before we adjourn, I would like to make a few announcements. After this session, we'll be moving to the dining area for a 20-minute refreshment break. Please gather in your allocated rooms for the presentation sessions afterwards. At this point, I would like to kindly remind you all that we have 4 keynote speeches coming up parallelly in 4 different venues. In the main hall, we have our keynote speaker, Chief Portner, addressing us. And then in rooms 1, 2, and 3, we have Dr. Amitabh Upadhya, Dr. Venkat Iyer, and Dr. Bommuluri Bhavana addressing us on their keynote speeches. Rooms 1, 2, and 3 are located past the dining room, and banners indicating their locations have been placed for easy navigation. Those assigned to the main hall can gather here after the refreshments. Furthermore, I would like to inform you that you have the opportunity to purchase the EdHat Law magazine, Rights and Wrongs, at a discounted price of ₹1,000 at the front. Once again, I extend my sincere thanks to all of you. Let us continue to learn, share, and inspire each other throughout this conference. Thank you and enjoy the rest of the event.
Thank you very much. As the coordinating secretary of the conference mentioned, you may proceed to your respective areas whilst enjoying the refreshments. Thank you very much, everyone.
business management, software engineering, system engineering, cloud computing, cyber security. There are many of these. And one of the ways to do that was one thing. Grow an international diploma and big psychology, teaching, human resource management. Level 3 या विद्यालय में EdHat International. A-level equal tadi pampian baru kayak job tadi nggak financial diploma dan master hardware. Ini masih ada
in Israel, and which also prevented major economic loss to GFOS Israel. During his time in Israel, Shev delivered guest lectures in international law at the university. Shev also worked for 10 years as a parliamentary assistant and political advisor to former Labour MP Tim Lewis Elman in Westminster. And during this period, he has drafted a briefing for Prime Minister Tony Blair while he was the Prime Minister about an important education matter in Liverpool, and for Jack Straw while he was the Foreign Secretary about a major issue in international law. Shev has an LLB honours from Greenwich University of London and an LLM in Public International Law from University of London. He is a fellow of the Higher Education Academy as well. So that's a bit of a brief about Mr. Shev, and I would like to invite him to give the keynote speech of the event. Thank you.
Good morning, everybody. Can you hear me? Yeah. That's good. Firstly, thank you very much, Anashika, for your very kind words. It's a real privilege to meet you in person, and I also just say hello to my good friend and colleague, Alison, who's in the audience here. But above all, I'd like to thank all the students here today for bringing up this session. Just a bit up. Can you hear me now? Yeah, that's better. That's better. So above all, I'd like to thank all the students for being here at this session. And I can see my good friend Dr. Janigan at the back, who's made this possible for me to be in your beautiful country today. So thank you very much, everybody. And I'm very pleased and privileged to be here at this amazing event. Now, today I'm going to be speaking about an individual in British politics who's made a contribution to public law, because I teach public law. Now, when I was a student at university, you had many people who are law students who said we don't have an interest in politics. And that was something that quite amazed me, because ultimately it's the politicians who make the law, the lawyers, barristers, advocates, they argue over the points of law, and it's the judges who interpret the law. So it always amazed me, there's such an interconnection. Now, what I'm going to try to do today, I'm going to try and make this lecture or my presentation funny at some points, but also engaging, and so that people in Sri Lanka, you don't come from the UK, will be able to relate to what I'm saying today. So, without ado, can we pass on to the first slide? This individual is Benjamin Disraeli, passed away in 1881, former Prime Minister of the United Kingdom. If you pass on to the next. Now, one of the reasons I have such an interest in Benjamin Disraeli is because I'm here as a representative of Buckinghamshire University. Now, in High Wycombe, it's renowned for the furniture industry, but it's also, my university is the nearest university to the country home of Benjamin Disraeli in Hughenden Manor. So this is High Wycombe, and that's the country home. So you've actually got a picture to where our university was based. Disraeli was a very interesting character. He found himself in debt for most of his life. He was born Jewish, but he was baptized at the age of 12, and then he lived most of his life, although he was very proud of his Jewish roots, as a Christian. But he's a very interesting guy. So here we're going to talk about Benjamin Disraeli's route. But I want to tell you a funny story before we go into this. Disraeli, as I said, was in debt for most of his life. Now what happened was, he had an admirer called Mrs. Beryl Williams, who wrote to him. Mrs. Beryl Richards, sorry. She wrote to him and kept saying, they had a correspondence. And she said, listen, when I pass away, she was a widower, when I pass away, I want to give you a sum of money. I want to give you £30,000, which is worth £2 million, on the condition that I can be buried next to you. So when she passed away, she gave Disraeli £30,000, which helped to pay off the mortgage on Hughenden Manor. And she passed away, and she was buried in the church in Manor, and she's actually buried next to Benjamin Disraeli. So you've got Benjamin Disraeli's wife, you've got the widow Mrs. Beryl Bridges, and Disraeli himself. So he was like a business transaction, but she got the privilege of being buried next to a former prime minister. Now, Benjamin Disraeli, as I said, one of the things that people know about Disraeli, and he's perceived in the wider world in the United Kingdom, he's perceived as the first Jewish prime minister, although I said he was baptised by his father at the age of 12 because he had a dispute with the synagogue in East London, the oldest synagogue in the UK. His father was a member of the oldest synagogue in the UK, Bevis Marsh, which I actually am a member of as well. And they had a dispute and had a falling out over fees to the synagogue, and he took his son out of the religion. And while his father never converted to Christianity, he converted his children. But in the United Kingdom, amongst people who know these things, he is considered to be the first Jewish and only prime minister. In fact, there's a Jewish festival called Hanukkah, and Prime Minister Sunak hosted the reception for the leaders of the Jewish community, including the chief rabbi, and he made the following point. I may be the UK, and we all know here that Rishi Sunak is he's the first Asian Prime Minister of the United Kingdom. And he made the following point. I may be the UK's first Asian Prime Minister, but we had the first Jewish Prime Minister 150 years ago in the form of Benjamin Disraeli. Next bit, please. Okay, now, I don't know if you remember when Barack Obama was elected in 2008, it was considered to be an amazing feat for a member of the Black African American community to become president of the United States of America. It was talked about throughout the world. People thought that would never happen. It happened. But there's a political commentator called Nick Robinson who works for the BBC. And he made the point, a very important point, that Disraeli becoming Prime Minister with the level of anti-Semitism in the UK in 1868 and 1874 was equivalent of Barack Obama becoming President of the United States in 2008. In Victorian times, it was just as remarkable for a man born to be Jewish to become Prime Minister as it was in 2008 for a man who descends from the African American community to become President of the United States. Next bit, please. Just go back a bit. Now, as I said before, he was the most unlikely Prime Minister, did not go to university. He was deeply in debt for most of his life. He invested badly at the start of his career in a South American mine, which went completely wrong, and he was bankrupt for most of his life. And in fact, he had to keep moving from area to area because he could be arrested. And when he was an MP, one of the things that he stood for Parliament is because he got immunity from being arrested for debt. He was extremely eccentric as well. He liked older women, for example, in those days. And he was a bit of in his earlier days, he was a bit of a player of the field, as I say. But let's go on to the next slide. And this is something that I think is relevant to people in this room. Next slide, please. Now, we all know that the language of international diplomacy is English. But it wasn't always the case. Up until the Congress of Berlin, the language of international diplomacy was French. If you just go on further on that slide. Now, as I said, he never went, so they had a major conference looking at the whole issue of Bulgaria in 1878, the Balkan crisis. Now, Disraeli attended the conference, and there was a major problem at the conference. The problem was that as I said, the major language of diplomacy was French, but because he never went to university, he only knew really English. So what should we do? We've got a serious problem. The guy can't speak French properly, he can only got basic French. What should he do? So the British ambassador at the time persuaded Disraeli, you don't know French to a relevant standard, why don't you deliver your speech in English? Anyway, you have marvellous oratory skills in English. And that's what he did. And it's from that time onwards that English started to be the language of international diplomacy. And as I say, it's relevant here because when you have the Foreign Minister of Sri Lanka goes and conducts negotiations abroad with his counterpart, it's generally conducted in English. So this is where the process of the language of diplomacy started to be in English rather than French. If you just go on further on. Okay, so we've covered that. It's the next slide. Okay, we cover further on now. So this is another thing in the Congress of Berlin. There's a very famous phrase that was utilised by Neville Chamberlain after the Second World War, where he talked about bringing peace with honour. This was actually said by Disraeli first after the Congress of Berlin. So Chamberlain's words were infamous. Disraeli's words were well respected at the time. Next slide, please. Okay. So one of the things that they say about Disraeli, that because of the Congress of Berlin, he had an impact on the bringing together of Bulgaria as a country. Next slide, please. Okay, now, this is where the law comes into it. I teach public law. Unlike Sri Lanka, in the United Kingdom, we have an unwritten constitution. What do I mean by that? I mean that we have a constitution that is not codified into one document. For example, as you know, the United States of America has a United States Constitution written in one document. We do not have one document. Our constitution is not codified, it's written down in certain parts. For example, legislation forms part of the constitution, legal judgments, and of course, something that I'm particularly interested in is the whole issue of constitutional conventions. They're not legally enforceable, these constitutional conventions, but they're understandings that you're going to abide by a certain behaviour when dealing with constitutional matters. Okay? So, for example, there's nothing in law to say what happens after a general election, but it's a convention that the Prime Minister can command the support of the most MPs in the House of Commons will form the government. That's a constitutional convention. There's similarly other constitutional conventions. The Queen, now it was the late Queen, but now the King, will always sign bills into law, royal assent. So these are kind of understandings. They're not written down. People would describe them as gentleman agreements in a way, the old-fashioned term. But their understanding is how you should proceed when dealing with matters of constitution. And what's very good about it is the United Kingdom constitution is very flexible. So it can deal with different situations. So for example, in America, they have problems. There's debate about controlling guns. There's a debate. They can't get it passed through Congress because in order to ban guns, you need a 2/3 majority to amend the constitution in the Senate. In the UK, you just need a simple majority and you can pass a law and you can deal with certain matters. So, for example, in 1997, there was a massacre where someone in the UK school went into the school, shot people. Initially, they moved to pass legislation after the general election, which banned guns. So it's very flexible, the constitution. So they also regulate, as I said, the conduct of the monarch, government, individual ministers, parliament, and judges. Okay. Now, sometimes constitutional conventions can work to your detriment as well. So, for example, once I was giving a talk to my students, and we had a discussion about the future of the monarchy. There is only one place in the United Kingdom that you can't discuss the future of the monarchy without the permission of the monarch. Does anyone know where that is? Anyone got a clue? Okay. The only place you cannot discuss the future of the monarchy in the United Kingdom without the permission of the monarch is actually the British Parliament. In order to ever have a debate about the future of the monarchy in Parliament, you have to have permission of King Charles III. That's like a constitutional convention. Some people would argue that's detrimental. Of course, individual MPs can say whether they believe there should be a monarchy or not. but you cannot have a debate about the future of the monarchy in Parliament without the permission of King Charles III. Next slide, please. So what are examples of constitutional conventions? And this will have an impact, even this is also, I think, relevant to people living in Sri Lanka because you have a cabinet. So constitutional conventions, they develop the whole notion of cabinet. And remember, the United Kingdom is considered to be the mother of all democracies and help contribute to the development of the governmental system throughout the world. Obviously, you need to, if a government, for example, can't command the support of the majority of MPs in the House of Commons, it has to resign. And also, ministers should be held to account. If I'm the transport minister, I need to be held to account for transport policy in the United Kingdom. And obviously, constitutional conventions, it created the whole, there's nothing in statute until recently, we talked about Prime Minister, but it created the whole concept of having the office of a Prime Minister. Next slide, please. So, well, we can really, and this slide we can actually skip in a way, but it just basically, as I say, constitutional conventions governs, for example, the role of the monarchy. So, for example, if we were living in the time of King Charles I, the powers of the monarchy were greater than they are now. For example, one of the powers of the monarchy was the defence of the realm, which means it was responsible for the security of the United Kingdom. Ultimately, the first responsibility for any government is the security of its citizens. So the security now of the United Kingdom is invested into the hands of the Prime Minister. This is a power that's been transferred from the monarchy. Previously, it was a power of the monarchy. Also, there's the whole notion of treaties. Treaties used to be come into existence, and then it was basically agreed, but it was basically a constitutional convention that any treaty signed by a British government would have to automatically be ratified. That was changed. Now you can ratify treaties in Parliament. Clearly, certain treaties are always ratified in Parliament, but some international treaties previously were not ratified, but rather were agreed to on the basis of a constitutional convention that the government of the day had entered into this agreement, and therefore by convention will be implemented. Next slide, please. Now, as I say, constitutional conventions can be codified. Now, in the United States, for example, and most people in this room will know this, if you're President of the United States of America, you can only stand for 2 terms. You can't stand for more than 2 terms. This is why Barack Obama, for example, in 2016 had to stand down as president, or Bill Clinton. In 2000, he stood down as president because the Constitution states that you can't stand for more than 2 terms as president. Now, this is quite a recent development, because up until 1955, it wasn't written down anywhere. It wasn't part of the Constitution that you stand for 2 terms only. It was a convention. There was a convention by presidents of the United States of America up until FDR, Roosevelt, that he would only stand for 2 terms as president. Now, Roosevelt, what did he do? It was, of course, very serious circumstances. He actually was president for 4 terms. So hold on a minute. They said, look, there's a convention. The president should stand for 2 terms. And yet Roosevelt broke that convention and was president for 4 terms. So what they did, they actually amended the United States Constitution in 1951 by 2/3, which stated, they actually codified the convention that no president of the United States of America can be president for more than 2 terms. There was a wonderful, interesting exchange. I mean, when Donald Trump became president of the United States, I know he's a very controversial figure, but he produced a letter from Obama. And he said, it's very nice of President Obama, previous president, to write me a letter. In fact, in America, they call all presidents, whether they're ex or even presidents today, they call them presidents. But he said it was very nice that President Obama gave me this wonderful letter just as I was entering into the Oval Office and Obama was leaving. He obviously didn't study American constitutional law because it's a constitutional convention that when a president changes, so for example, when Obama left office, it's a constitutional convention. The president will write a letter for the next president giving him some advice which he leaves in the Oval Office. So that's a constitutional convention in the American scene. Next slide, please. Now, why did I say I think people in this room can relate? Because everyone knows that the United Kingdom, we've got a constitutional monarchy. Everyone knows in this room that King Charles III is our king. You don't have to be knowledgeable about the UK, you just know that fact. Now what happens is, after a general election, and this is where Disraeli changed the Constitutional Convention, you can change Constitutional Conventions based on precedent. After a general election, what does the monarch do? The first audience he has is with, the Prime Minister do? The first audience he has is with the monarch. Now, up until the time of Benjamin Disraeli, he became Prime Minister for the first time in 1868. And up until that time, what did the Prime Minister do when he was elected? He went to Parliament first, and then he went to the monarch. But Disraeli short-circuited this whole process, and he decided, I've got the support of the MPs in Parliament, I'm going to go straight to Queen Victoria. Disraeli was Queen Victoria's favourite Prime Minister. So he went straight to Queen Victoria. Now this is why today, when you have a change of government in the UK, the first thing a Prime Minister does is he has an audience with the monarch. This is why even when you have a change of leadership of a particular party, when Rishi Sunak became Prime Minister, the first thing he did was he went to meet with the King. And this all stems from what Disraeli did, that he decided to short-circuit the process and go straight to the monarch. So therefore he has had an influence on a constitutional convention which is part of public law in the United Kingdom. Further on down. So this is previously what I said, that you're going to go to Parliament. We can go to the next slide and explain it. Next slide, please. Okay. Another thing is, another convention, he said, is after a general election, obviously the Prime Minister now resigned. Previously, the Prime Minister wouldn't resign automatically. He would first go to Parliament as well. So nowadays, you have a situation whereby you lose a general election, you will resign as Prime Minister. Previously, you would go to Parliament first, and then you would resign. This is another constitutional convention developed by Benjamin Disraeli, and this is carried on until today. Okay, next slide, please, because I know we're time's pressured. Actually, when I was listed for this talk, they put me down for an hour and a half, so I thought, well, Mark's got a lot of time, but ended up with half an hour. Anyway, there's the issue of the 10-minute rule bill. The MPs now, there's a process in Parliament where you can introduce a bill and you can speak to it about for 10 minutes. Now, there was a great, in 1867, there was the Great Reform Act, which, you know, in the United Kingdom, as in all countries, the extension of the franchise, giving people the right to vote, developed over a period of years. So up until 1918, women didn't have the right to vote. In 1867, they extended the franchise by increasing the vote for working men from 1 million to 2 million. And this was introduced, there was a discussion called for 10 minutes in Cabinet, then they introduced the bill, became an act, and that's why it's known as 10 minutes, because the discussion in Cabinet only lasted 10 minutes. And nowadays, MPs have the opportunity to introduce bills into Parliament, promoting certain causes that are of interest to them, and speak to it for 10 minutes. So this is another constitutional convention that has originated with Disraeli. Next slide, please. Now, the thing I will say to you is this. Even if you're not interested in my topic, and you don't have to be, I will say one thing to you though. nearly everyone, millions of people throughout the world, including people in Sri Lanka, quote Benjamin Disraeli without knowing where the quote comes from. Disraeli that is his greatest legacy in my view. He's a progenitor of many different quotes. So I'll give you an example. Justice, and we're talking about law. And I think it was Dr. Janigan who mentioned the word justice or the key speaker today. But Disraeli was the originator of the quote, justice is truth in action. He was also the originator of the quote, fear makes us feel our humanity. Or, and this is one quote I like, because I'm always accused of being very frank, there is no wisdom like frankness. So millions of people, wherever you live, whether you live in Sri Lanka, Pakistan, United Kingdom, Germany, United States, there are millions of people who quote Disraeli because it's part of everyday language, but don't realise who was the originator of that quote. So I think that's one of his greatest legacies, that even he died in 1881 and we're still quoting Disraeli. Next slide, please. Of course, this is one of his most famous quotes that's utilised a lot. There are three kinds of lies: lies, damn lies, and statistics. So this is a very famous quote that's utilised a lot in the press in the United Kingdom, but I'm sure you would have heard this quote even in Sri Lanka, because I think this is something that people utilise. In the academic world, certainly in newspapers and other parts of society. Next slide, please. So at the university I teach, in Buckinghamshire University, well, that's a former Sky News anchorman, Mark Austin. I spoke to him about a constitutional matter a few years ago. But on the quote, on the staircase of Buckinghamshire University, there's a wonderful quote from Disraeli. A university should be a place of light, of liberty, and of learning. That's a quote from Disraeli, which is utilised around the world as well. So he's very famous for his quotes. In fact, they say that if you look at the English dictionary of quotations, they say that he's even got more quotes than Winston Churchill. So this is how his legacy lives on in terms of the use of the English language, quotes that people use throughout the world. Next slide, please. Now, I'm ending with this because I was talking about my next research. Hopefully I'll discuss about constitutional conventions. Obviously, some of you would have heard about the political crisis that's been taking place in the UK. The former Prime Minister has now been found to be in contempt of Parliament for lying. He's actually been banned from using the Parliament itself. And one of the things I'm interested in the whole area of constitutional conventions and how the Boris Johnson government seem to depart or seem to disregard constitutional conventions in terms of abiding by them. Because traditionally, as I say, there was an understanding that you would abide by constitutional conventions, and that Boris Johnson seemed to depart from that. It's been a wonderful experience to speak to you, and of course, I'll be more than happy to take any questions from the floor. If you've got any questions about my presentation, anything about public law in the UK, happy to answer your questions. I hope you found it interesting, but I would say three things at the end. Even if the Constitutional Conventions issue is not something that is really something that you really think about, but I'll leave on this note. I believe that everyone in this room throughout their life, at least once in their life, will quote Benjamin Disraeli, whether they know it or not. Thank you very much.
Audience, do we have any questions?
I don't bite, and I'm happy to take any questions. I'm a friendly person. So if you've got any questions about anything that you think about, ask me the question. Happy to answer. Any questions?
I think, Shay, we'll start the session so we can move on with the presentations. Thank you very much. So you could take a seat.
Okay. Thank you very much, everyone. Bye. Enjoy the rest of the conference.
Right. So just to let you all know the guidelines of the session, the oral sessions are going to be starting now. The guidelines are as follows. The time allocated for each presentation is 15 minutes, which includes 10 minutes of oral presentation and 5 minutes for question and answer sessions. The presentation should cover the research question, objectives, hypothesis, methodology, data collection, findings, analysis, and conclusion. All presentations are to be saved on the desktop with the abstract ID. The presenter may operate the slides or request technical assistance if required. And the bell alerts will be given as follows. The first bell will be after the 5 minutes of your speech, and the second bell will ring at 8 minutes, and third bell at the 10 minutes time up. Please stick to the allocated 10 minutes presentation. The presenter will be interrupted and stopped by the session chair if they do not keep to their allotted time. All presenters and co-authors will be given their certificates at the end of every session. All presenters, co-authors are expected to take part in the closing session, which includes the awarding of the best presenter, best paper, and the best research. No permissions will be granted to take a screen capture or record oral presentations and discussions in any session. Photographs taken by the official photographer will be uploaded to the conference website. Thank you. So, may I call upon the first presenter of the day? Yes, so we have with us Dr. Ernest, representing Pakistan Bar Council, on the theme of legal technology, a new norm to initiate change in legal sector.
Very good morning to all. I am really thankful to Dr. Jenigan and all his team that has provided such a great opportunity to be the part of this organization and conference as well. I really appreciate and would like to have a huge round of applause for Dr. Jenigan and all his team. I am representing Pakistan for this conference, and topic of my paper is legal technology, a new norm to initiate change in legal sector. This is very important that for the legal sector that we should use the legal technology more in order to be cope with the new systems. Before that, I don't know about the Sri Lankan system, but in Pakistan, there are some legal firms which are not being used the legal technology in a very smooth manner. But that's why I have chosen this, that what is a new norm? New norm means that we should have a authoritative standards to cope with the new technology. Otherwise, we will waste a lot of time when we do the practice for these things. For the next slide. What is the legal technology? How we can define it? There is a deliver legal services. We can deliver different legal services, and then the support the legal industry in different manner. When we see the different things about the legal technology, we see that the different legal services should be the part of the law firms in order to get equipped with the technology. As there are some common legal software which are used for the law firms, and these common softwares are case management software, billing and tracking software, document management and automation software, online payment processing. So before that technology, we are not being used these things in our law firms. Mostly when there are case management software, so these software update the system and your law firm that makes a single cloud-based server in which you get all the processing data for your clients. When there are billing and tracking software, before that, we don't have such opportunity to calculate the time frame for our lawyers, that how much time they are consumed in a single case. But when we are using this kind of software, we can easily calculate that how much time we have consumed at that law and whether we are getting all these things for such time which we have spent on that law. Document management and automation software, that is also a very important and allow us to automate document creation with the help of intelligent templates. Before that, when we are not having this technology, document management and automation software, so we don't have the templates. But no, we have the template for the specific cases that will help us to make all things very clear in a very short time. Online payment and processing, so easily the online payments can be done by the clients and they can get all the benefits for that thing that which we are having with the legal technology. What are the benefits for the legal technology? There are number of benefits when we adopt the legal technology in the law firms, and the number one is data, fast data processing. These are the benefits the first benefit is the fast data processing. So we have to use the artificial intelligence technology, and this can be dramatically increase the speed at which legal large search make us possible, and allowing lawyers to streamline the process of preparing for their cases. In order to fast growing procedures for the data processing, we can get the old cases from the data, and can help, these things can help us in maintaining our case. The second most thing which is very important, that advanced process transparency, that is a very good, you can say, legal technology benefit is the advanced process technology. That technology influence on the substance of the law is not a new, but there are number of things which are to be taken. A reduced error ratio, that helps our legal firms and lawyers to reduce the error, because when they are having some precedents for the previous cases, they can easily get through from the technology that what are the flaws and what are the next things which they have to be add in the case. And then high scalability and globalization, and this is very easy, that we have to be the scalability of the case, and how we can get help from the from the globalizations as well. Next slide, please. We have the different research questions from our legal lawyers, that how we can cope with the legal technology, and they have provided us with the number of questions, and they you can say that they appreciated that legal technology should be the part of our legal firms. Next slide, please. Next slide. So the objective of this case, the objective of this paper, in the light of the legal technology, the purpose of this paper is to outline the advantages and changes induced by using legal technology. So basically, the whole thing is moved around the technology, that we must use this in our system. So the methodology, next slide. That survey-based methodology, we have the 25 questions based on the different technology used, and the members of Bar Council and different lawyers has provided us a different kind of their notes, and then after that we have thought that it should be the major part. And what are the results when we have this technology based, and next slide, please. These are the results in which we can ease in managing the legal cases. When we find these after the 25 questions survey, it was noted that ease in managing legal cases is very easy when we are using the technology. Dealing with the clients, because the clients are much fast when they think that the case should be taken by our legal firm, and it should be decisioned at once. But when we think that we are using this legal technology, that makes us that dealing with the clients is very, very easy. We are getting all the information to them with all the technology help. The third one is the overall data protection, and technology basically confirms that the overall data protection, because when we are having some specific software that can only be used under the such protocols that save the cases, reduce the risk of error, different errors are being reduced, and all the matters should be in their legal law firms, and they have a complete access from anywhere. And in the new innovation that makes us a new innovation for these things, before that, the law firms are not being able to get these things in a very fast manner. But when they have used the legal technology, they are being using it in a seriously, and they are getting it a benefit from that. There are next slide, please. So when we are having such kind of technology which is used in our system nowadays, so we should, as you know, that the banks have taken that technology and they have grown tremendously. In the same way, if our legal firms can take this kind of technology, they can get ahead. Thank you very much. So you can ask any question if you have. Yes.
So you said about this I know, but how about the dive cost? So they can take a dive to the changing or things and afterwards things. So other things it cost. How we are these things? Example in Sri Lanka, we have a lot of cases still running. I mean 19, 17, 18,
Yes.
still running. So how you like where is it? How it costs?
This is what that when we are it's at cost effective as well, because when we are using the software, we can have the exact timing and exact system that we can produce. And if there are in cases, there are some cases from the 1973, but they are yet not decided. I think that they will not be decided in future as well, because it takes a lot of time. But these technologies, as you know that in the 21st century, these technology mostly are used in the different departments. So that's why we are also hoping to that these technologies should be used in the legal sector as well.
You think this one cost effective?
Yeah, it is a cost effective, because when we can communicate easily, we can send all the documents through our emails, it's a very fast processing, and on the same way that number of papers are also being reduced, and it is a paperless system as well.
How about privacy? We know about law. We can't use some cases, we can't put it outside. I mean, running cases. So how about privacy?
How much?
How about privacy? Private,
Yeah, because as you know that in the privacy protection, data protection is the mostly used by the softwares. So that is the most safest way as well.
but we have everywhere hackers there. So how you protect that thing?
But this is you can say the hackers are for all the systems, not only for the lawyers, not only for the lawyers. But this is as you know that the cybersecurity has taken place to protect the data as well. So there are a number of methods which we can reduce the things.
Thank you, Dr. Fahim, for the very interesting research study. Really appreciate it. But wonder whether you got a chance to find out the response of the judiciary with regards to the use of technologies.
Yeah, thank you, Dr. Fahim, for this very interesting study. I just want to find out whether you were able to find the response of the judiciary with regard to the use of technology.
Basically, this is for the law firms, and they are using it by themselves as they are making their files. So I don't think so that judiciary has any kind of jurisdiction on that they shouldn't use it.
Thank you very much. It was very interesting session from the expert. What I would like to know is knowledge of law for everyone is the theme of this conference. Whereas you have done a very good study on legal technology. How far this will help to fulfill this theme, knowledge of law for everyone, when we, in terms of implementing this, what we call legal technology, and how far it will be beneficial to everyone. As the gentleman said, there are judiciary restrictions, and how far this will be friendly, well, to use, friendly use for this particular legal technology in this regards, knowledge of law to everyone. That's our theme. So how it can help, how we can make it help.
Knowledge of law for everyone, that relates that everyone needs a legal support when it is needed. So whenever we have a good legal support without the technology, that means that we are providing a good legal services to the client. And when we are providing the good legal services, that means that everyone is going to enjoy for the law.
What are the future research can be found?
Future research?
Yeah.
It has
what are the future research gaps you found in this paper? I mean, right after you did, so there has to be some further research.
Yet we need to discuss it in future. Thank you.
Just going to ask you a very brief question. Sorry to be a nuisance. What you're talking about is it seems to be a digital revolution in the legal sector in Pakistan. Now, I'm not an expert in the Pakistan legal sector. Firstly, what is your time frame for this? Because clearly, I agree with you, you need to move quickly on this, but what time frame do you have? Have you put cost to this for law firms? And secondly, in terms of the judiciary, for example, judges in the UK now, they refer to precedents by using laptops and previous technology in bringing up judgments. So I think, obviously, it'd be very beneficial for judges. They can look at previous cases, they can just bring it up via technology. In the old days, you're looking into it via books and case rules. But my two questions is, what's your timescale? Do you think this is going to happen? And what will be the cost to law firms in Pakistan, and can they manage the cost?
Time frame about this, that when we are in a practice that when we use the technology in different departments, we do all the things in a very fast processing way. So I think that when we do these things in our law firms, that means that the case which has taken for weeks to prepare themselves to be present in the court, so they can do these things in a very short time. So I think that the time will be less than the routine if we are using this. And the cost factoring that these different software which are being available in the market. So when we are having the different workforce, then among that if we are using software that will be more reliable and more, you can say, it will be give us a good average in each and every way. In each and every way, they will provide us the things.
Thank you, Dr. Nest. Thank you, audience, for raising questions. Okay, so let's move to the next presenter. Mr. Iyer Rodrigo. Mr. Rodrigo, move to the next presenter then. Mr. Devon Shivanta Piris, the presentation number 3 on the segment Determining Personhood, a critical analysis of human personhood from a legal and a philosophical perspective. Over to you.
Good afternoon, ladies and gentlemen, good professors and my dear colleagues. I am privileged here to stand before you to present my presentation on determining personhood, a critical analysis of human personhood from a legal and a philosophical perspective. Now, the concept of personhood, as I would say in the beginning, is the heart of understanding of the rights and ethics and of our very existence. So it should be understood in every possible way, right? So human personhood should be understood in every possible way that it could be understood, right? So that we can get a deeper understanding of its complexities and implications, right? So as it says in this presentation, right, person in Greek, right, means the masked and individual way. That's the etymology of the term, right? And then in a legal sense, a person is identified as an individual existence with rights and duties. So it's kind of a moral approach. And then when we move to the philosophical approach of personhood, it is an individual substance with a rational nature of, a kind of consciousness is involved. So why determining personhood from a legal perspective is important? So after all, why should we talk about personhood from a legal perspective and of course a philosophical perspective, right? So we make laws from the legislation. So if we are to make laws, we should understand the subject or the object of the law, right? To whom we make laws and about what we make laws. So understanding human person, its attributes, its complications is important in making judgments and in making law. So the research question I have brought up is if the legal and the philosophical understanding of the concept of person complements each other for a better development of the human rights. So thus, these two understandings complement each other. So the methodology that I have used for my research is qualitative. The primary sources are the legislatures, case laws, statutes, and conventions. The secondary sources are the books, research papers, articles from both internet and journals. And the survey is autonomy of the human person. The survey that I have conducted earlier was regarding the biotechnology and how does it affect the human dignity regarding all these stem cell researchers and stuff. So the analysis of the person from a legal arena. So critically analyzing personhood from a legal perspective entails in acknowledging the fact that using biological attributes as the sole criteria for determining personhood is not effective. So when we determine personhood from a legal perspective, we should not restrict ourselves only to the biological perspective. That means it's a human being and all. We should not restrict ourselves to that only. But we should go ahead from that, right? And then we should understand the concept of consciousness, morality, and in that sense, we should add those attributes, collect those attributes, and then interpret human person in the arena of law. The individual human being governed by man-made law. That is, after all, in the legal arena, the humanity or human person is governed by man-made law. Then developments throughout the history. Right, so in the eyes of law, now we can see in these pictures, right, the developments that has been done to the personhood, how we were at the beginning and how we are now. In the eyes of law, the slave is not a person. That was Virginia's Supreme Court, but now it is not. The statutory word person did not include women, but it was earlier, but it is not now. The word person does not include unborn, right? It was earlier, but now we know that it is included. So the moral agency is another aspect that we should integrate with our understanding of the human person. We move on to the philosophical arena, right? So the rational nature is one of the key aspects that we should highlight in the area of philosophy to understand about human person. Philosophers since the day, right, since the beginning, we have been thinking and we have been trying to understand what human person is, right? If I to bring you philosopher Aristotle, he would say, know thyself. And Rene Descartes, cogito ergo sum, I think, therefore I am, about the existence of human being. So in the philosophical arena or in the philosophical background, the aspect or the notion of human personhood has been developing, taking turns, right? So I would say that these philosophical insights should be attributed or should be taken up by law in understanding what human person is and in passing judgments and legislation regarding the human rights mainly and other aspects as well. So Socrates and Plato would say every man is composed of body and soul. Descartes would say, I think, therefore I am. So this is the findings, I mean the conclusion, or else the peak. And a person in law is an entity who possesses rights and hence obligation by default. So as I said earlier, the understanding of human person from a legal perspective is a kind of a moral approach. Then from a philosophical perspective is an entity with a rational nature, a conscience, with the delicate interplay between body, mind and soul. It is a metaphysical approach. So our question is, does these ideas complement each other for a better understanding of human rights or human persons in a whole? I have gained this from philosophy, that I do without being commanded, what others do only for the fear of law. So you see how philosophy and law can go in hand. So these are the complementary relationships of human rights, or the understanding, I mean, more than human rights, these are the complementary pathways where philosophy can help law and law can help philosophy in turn. Right? First is enriching legal interpretation. Philosophical perspectives enrich legal interpretation by providing a deeper insights into moral and ethical dimensions. So as I said, philosophy can help law or the legal jurisprudence to enrich its understanding about human person in all the aspects. Second, filling legal gaps, right? So precedence comes here of previous case laws can give concrete examples, and the ratio of the court are examples or instances where philosophy can help in understanding the judgment of the cases. Next slide. Enriching guiding legislative reform. So legal reform should take insight from the contemporary philosophy. Now I would highlight the word contemporary here. Now we have many philosophies from the beginning, and modern philosophy, Western philosophy, Eastern philosophy, but our law reforms should always align with the contemporary philosophy, the contemporary understanding and the thinking of the society, the pulse of the society. That is how we can be effective in our courts. Next slide, please. Then this is how the law can help philosophy in turn. Case laws and precedents. Legal decisions and precedents derived from real life situations and disputes. Right? So case laws conversely provide concrete situations and opportunities for the philosophy to develop. For example, a case could be there where there can be no ratio. right? So in that case, a philosophy could be developed. The last is philosophical coherence. That is, now not all philosophies are correct, not all philosophies are wrong, right? So there can be philosophies that could be accepted, there can be philosophies that could not be accepted. So there was a philosopher who could say a man is just a machine without any soul, without any conscience. But another philosopher would say a human being is body, mind, and soul with a conscience. So there can be philosophy which are very different and opposing each other. So that does not mean one is wrong and one is correct. But with the contemporary pulse of the society, right? So law should be able to guide philosophies and to accept what is correct and to leave out what is not approachable or not probable. So the other thing is now how does this all philosophies help us in understanding the law and what are the concrete examples? So European Convention of Human Rights is one example, and then UK recognized the personhood of individuals with disabilities through legislation through the Equality Act 2010. So these are concrete examples where we can see philosophy and the development of philosophy has been adapted and adopted by law. Right. And then, as our speech today, as our theme today is knowledge of law for everyone, and I would conclude my presentation here saying that the knowledge of law and the understanding of human person and in a whole, everything, right? Everything, the general understanding of law and the human person should be given to all individuals of the society. So today we hear about many murders and inhuman acts, right? So these can be minimized. I would say that if we have a clear understanding of philosophy and law integrated into our, as the keynote speaker today said, into our curriculum, and then thereby develop the mentality of our future students and our society so that they could integrate both of them, the law and the philosophy, and treat humanity with dignity. Thank you.
Audience, over to you. Do we have any questions?
Devon, would you be able to explain about the research question a bit more? About research question that you were explaining on humanity, on that point a bit more? With the philosophical aspect.
Sorry, miss?
With the philosophical aspect.
With the philosophical aspect. So the research question is if both the legal interpretation and the philosophical interpretation complement each other, right? So why I chose that research question is I think our legal interpretation of humanity and the human person should always be guided by philosophical approach. Otherwise, we would not base ourselves. There would be no base for our judgments and maybe our understanding the legal aspect. And why in the other way around, our legal and the juries and the precedents and the case laws should always be there. Law should be always there to guide the philosophy. Because as I said, there could be various erroneous philosophies, right? So law should be able to derive what is pertaining and what is ethical and then leave out the rest. So that is what I said, they should complement each other rather than oppose.
Any more questions? Right.
Thank you.
Right, so we have the last presentation for the session on the topic of influence of social media usage on sexual abuse among the adolescents, Sri Lanka, by Mr. S. Amin.
Good afternoon, everyone. Thank you very much for this opportunity. To the law for everyone, colleges and ladies and gentlemen. I took one title, Influence of Social Media Usage on Sexual Abuse Among the Adolescents in Sri Lanka. This is very interesting and some people don't know about it. But even though this is very important knowledge, we should be understand world we are going, what happens in the world. So we should understand through this presentation. I think so. The 10 minutes not enough to presentation for this subject because this is very large of statistical and researches in this history. Even though I can explain briefly in 10 minutes, adolescence. Adolescence mean world defined the period between 10 to 19 years of age in the phase of transition from a child phase into an adult phase. The thing is 10 to 19 age. It's like kids, but adult sons, they call adult sons. Normally, social media, we call Facebook, Instagram, and Snapchat, IMO like that. But we don't know more than 60% social media in Google Play Store. They're using, 90% people are using. It's mean, not the people. The adult sons, kids are using in that home. So there are several issues come to the end of this uses. Normally, age 10 to 19 is the stage of human developing that cases significant changes in the physical and psychological well-being of every male or female individual in society. First, we want to understand, so influence of social media, the cross with the interactive activities and knowledge and abuse. What is the social media? Social media called, we are using anything, everything in life now that is social media. If we want anything, we are ordered on social media. If we want learn, we are searching in Google. If we want anything buy from shop, we are using social media. So all are in social media. In the world now running in social media, we can say, we can analyze the social media one by one. Is the first stage of the social media, second stage of the social media, and third stage of the social media. But we know everything is social media. Social media is digital technology now. Now, nowadays, China introduced artificial intelligence. So they are introduced the company and they are introducing any product from the technology and they are selling the product from the social media. For example, Amazon and Alibaba and Daras, like that. But those social media using not a teenage people, they're using adolescents also because they are attracted with that. More than 4.7 million people around the world social media using media. In that 4.7 million, 90% is teenagers. In that 60% people, it's like we can call kids or adolescents. Futures at the generate content in personalized profiles that lend themselves to engagement, view, likes, shares, comments, and discussion. It's a best. We want to think this is an important thing because Other sons are thinking if you upload our personal photo, if you upload any program or something there, we can get a shares, we can get a likes, we can earn from the social media companies. So that's why they are going to do the uploading. You can see the graph statistically. 46.36% adult sons are using in social media. Social media, we are calling and we are telling about the social media. But we can say now that 46.36% is going to the influence of the abuse. Why? Where they are going to that way. So we can explain that. If you are seeing the Facebook, that will some advertising coming to the Facebook or any social media. You can't mean the adult sons can't go out because that attractive. Sexual advertising 90% in social media. Other thing is we want to know the children's staying at home in 10 to 19 years old people are staying at home. Normally, they are studying at home with the parents. The parents are working in the outside or their parents are going to the foreign or abroad and working there. But normally, they have the more time spending at home or schools. The school friends are talking with attractive. What they happened yesterday, today what happened, tomorrow is what. But they all are talking is social media. They are not talking in knowledgeable anything because they are attractive in ads. Other things we can understand. 38 porn apps. It's mean adults apps is there. There are no any restriction for the login. There are no any restriction for the adult or anything. 38 apps is there. So when the child's going on there, they open the social media, the app is open. They are seeing is there, but they don't know about it, but they attract you because they mentally they are growing. Then physically they are fitting because of the age 90 to 10, 10 to 19 age. You can see there one of it is topics of post in social media. It's called political benefit, religion, personal problems, and dating life, emotion, family, accomplishment. So those things are only the people are uploading in the social media. People mean I call here adolescents because they won't upload anything from the home. They want to upload their food. They want to upload their pictures. They want to upload something in the relative anything or something. But they want to get a like and share before I talk about it. So they want to like and share and comments and get earning from somewhere because someone talk to him. If you are uploading here, if you are getting the 100,000 likes or something, you can earn something. But people they are trying to go for that purpose, but unfortunately they are going to abuse. The recently, the statistic of Sri Lanka after 2021, 60% abuses happened here. Last time also, in this year and last year also happened is one school girls raped I think more than 100 people. It's like rape because the age under the 18 years old we can call rape, but she went for the some people and she used for the abuse. So it's happened finally the report saying she is using is all things in social media. After that only she addicted with the drugs. So drugs also introduced from some friend from the messenger. So we want to know what happens there in social media. People advertising in their good market and bad market and negative market, then positive market also. The people are identifying who are in the social media a long time, who are in the social media and very active. Then they are sending the message their business. It's like drugs and other things also. So those things are very influencing the child abuse in Sri Lanka. In the last year, 60% has happened in child abuse in Eastern Western province. Other thing is we know, we can understand about it. The people, so people with adult sons, they get smartphones. They don't have that any normal phone because they want to use the smartphone for the social media purpose only because there is nothing because the 10 to 19 ages they can't get any knowledge for the research from the any university in UK, any relative research or something is anywhere from the world, but they don't know about it. They're attractive, they want to they want to go for the social media, then get some message, then attractive with the same age people, otherwise the other people. Then they are communicated with the other people things and they are marketing the other people, the negative market, they are going to the abuse. Then other thing is I already said, but in case we can explain about that, those are lead high risk of the behavioral issue in adolescents such as sexual activity, sexual violence, and unwanted activities related to sex and obsessive abuse. Yes, these things are, I've already said, the drug issue. The thing is, normally now the police and other criminal cases they will find in the phone call and other things also. But the social media is, they can't find, they get so many time or long time something. They want to find who are people sending the picture, who are people doing this. So take this time. So these things are using for the adult science because the people, the market people, they will send the drugs dealing or other things as some product of there. They're selling there through the messengers or through the Instagram. So someone there because the 27% after the 2021, the recorded here in research that those things are happening in social media. Then we can see the Sri Lankan update. 2011, 2012, until 2018 and 2019-13, the percent of resolving complaint, 59 complaints is happening there. So we can analyze how the influence of social media directly with the kids or adolescents. 2020 and 2021 update of Sri Lanka, you can see 72% all type of abuse area in sexual. So all type of area mean in all islands in Sri Lanka. Normally the abuse, two type of abuse happen in Sri Lanka. One is abuse happen for the parents are going to abroad or parents leaving from the children. Second one is influence of social media. In 72% happen social media. Some people are not talking in society, but some people are talking in society and complain the police. That's why the social media influence the people didn't understand as well. I can see these articles in last 10 years in social media influence of in adolescents. So many characters. It's me. In Eastern Province, so one girl raped from the 4 people. It's happened is there, that girl 8 years old, but she studying grade 7, the mother is there, the father is there, but this is abuse for people, how they happen. The police searching there. So I want to say this subject because you want to understand what happens influence of social media. That girl using social media from her friend phone. She don't have the phone because she is in poverty line. This is a critical area in Eastern Province. The article says, one of article, I can show it. Then she said she using the one of social media from her phone through the messenger. The one person's after 30 age teenage persons and the adult one, he messaged to that girl and she's like going to the teach. Then after the end of the day, she abused that girl. Then after he talking too much and talking too much and give some money because adult sons, it means kids need some things and she attracted with the modernization world, so she need a new phone, she like that, so she need something in the market, no, so she attracted with that person, so he spent the more money with her than she went to other people. This is a very, very, very heaven is very narrow thing is here, but it happens in Eastern province. This is also influence of social media. These things are happening in our home, so we don't know about it because we are not searching for our child. We are not changing our children because we know the movies are closed. The people are studying, but this happens here. People are doing something different with the friends because friends are different. Two types of friends, on the bad friends and good friends. We don't know who is the bad, who is the good. So finally, end of the day, in police station only we can understand what happens in future, what happens in past, in present. So we can go for the end of the presentation to identify the abusing the content among the adult sons. So we know how can we identify the adult sons in influence of in social media. Then we know the age of limit, 10 to 19 ages, they are mentally not fit, but physically they are growing. So we know that they are the shape, they are what are they doing in today in yesterday, what they did in tomorrow, what they will do. So we can understand their lifestyle will change. The newly they buy the new phone. So we want to ask how they buying the phone. We want to ask that. Other days they went later on he came to the home. So after the class, the 3 o'clock end of the class, but she or he will come to the after 4 o'clock. So we want to ask, why are you coming to the late? So these things are happen in social media influence because that people are the people are connected with the people in the social media, those things.
Ms. Young, I think we have run out of time. So, yeah, it's a very interesting topic. So I know it could go on for minutes and minutes. And so I would like to give the opportunity for the audience to raise questions. Yes, you're welcome.
Excuse me. Now you say like influence on the media is harmful to the society. Okay. So my first question. So in Australia, if you're living there, the schools given to the laptops and tabs for the school children, but they're locked. You can't go for the other websites or whatever. So what is your purpose? Like you said, these things bad, these things. You know how many percentage in the market or like sellers selling through the Facebook and TikTok and other whatever social media. You know how many market percentage they take. Look for selling to their products. So according to your things, your research, you already said the bad things, bad influence. So how you weigh these things?
Yeah.
What is your plan? You have the plan. Okay, we have to give these things, that thing,
That's a great question because we are talking Australia, the scenario, right? Great, because you are saying Australia. That's the thing. I am talking about the Sri Lanka. Then other thing is you say, why are you telling us all the bad?
I will tell you. These all things coming after in Sri Lanka because of Corona. Because school closed and stuff, that's why the social media, whatever the phones they're using most of the time after Corona. But I'm talking about last 10 years, Australia and other the big countries, they're using the tabs and computers. They give for their the works. So school work, they're uploading everything through their laptops.
Yes.
School given to them.
Yes, you are correct. But even though there are two types of India, because we are in developing country, right? We can't equal to Australia because I don't know. You say the restriction and they can't go and log in something, But in here, in my research, so I get so many articles with the proposals like that. So I analyze the literature review. Then there is a 38 website in phone and adult website. Yeah.
But you said in Sri Lanka they're using proxies and VPNs, especially proxies they're using. So whatever you put in the bar, they can easily go through the proxies on any site.
Yeah, you say okay, but as a father, you can do it with your child. Then the child not going like this, no? They can get a restriction. They can't go there anywhere. Then they can use only for the education purpose or something, right? But in Sri Lanka, in some area, the coastal area, in eastern, northern, in some areas there, that people, the uneducated people is there, but they are buying the phone. They are giving the phone to their children because they like very much the children. The people like very much the social media.
But you're like your research, you said all things bad. You know, India, most of people, like why they have the brilliant people, they make brilliant, IT people. So how?
The IT people mean, what is the age limit, sir?
No. They have the school, they learn and they give it to teach them to learn, the ICT.
What I am saying here, there is no restriction in this age limit. The people are not giving. It's mean the fathers of families not giving that restriction to the mobile or anything. But I know I have the phone, right? There is no restriction. Then my brother or anyone can use now. Then we don't know that what they are using is there. Then after the end of the day, they are using something. Then they are connected with the other people. When they get a phone, they are connected with the other people. That's the influence of the social media. What I'm trying to say here, but I'm not totally saying the bad thing is a social media, because social media is very important things. It's mean number one, the world best richest person, or number one, the business person using the social media. Twitter owner is a social media. Mark Zuckerberg is a social media person. He's the richest person. Right? I know very well about it. But I'm telling you this. I'm telling you honestly. The 10 to 19 age adolescence age limit is very attractive with and other people with the social media influence that going to the abuse. Thanks.
Stanley, just a question. Like what you said was like 100% true. Like social media has its pluses and minuses. So based on your topic on, the age limit 10 to 19, so you're looking on, social media and that aspect. Now, since the conference is a bit on law, if you can just link a bit on the general aspect, which you said very correctly, with the legal aspect, that would be a bit better. Will you be able to? Yeah.
Can you ask again? It's a legal side.
Just the legal side,
okay. The
what
thing
are
is,
the laws and things like the Sri Lankan aspect? What you said, a bit in law.
Okay.
Thank you very much for your presentation. You mentioned that there was a definition of adolescence between the ages of 10 to 19.
Sometime 18.
I wasn't sure where the definition was taken from, because there was no in-text citation there. But also the graphs that were shown, they weren't also clear to me as to where that data was collected from. Also the age range there between 10 to 17. So could you explain the decision behind only looking at analysing data between the ages of 10 to 17 and the definition was between ages 10 to 19, please?
Yeah, 10 to 17, right?
That's what was on the graphs that were shown, yes.
So can you ask again?
To the gentleman there, if you could go back in your presentation to the graphs that were shown, please. This one.
Okay, ask me.
So it says here in the key, we've got only up to the age of 17, and from the age of 13, yet your definition of adolescence was between ages 10 to 19. So I was wondering why only these ages were analysed.
Okay, fine. You can see that circle means like 10 to 17 age, right? Is boys and girls.
We've got age 13 to 14 and 15 to 17 the key.
15 to 17.
So why does it only start at age 13?
Yeah.
When your definition is from age
Yeah,
10?
my definition is 10 to 19,
Yeah.
right? Yeah, I got it. Then 10 to 19. But here, I analyze the age limit for they're uploading social media topics. The thing is, they're uploading political benefit post. They're uploading regional post, regional post. Other thing is dating life, like that they went to the dating life app. Other thing is they are sharing the comments like. Then after emotional, there's someone is emotionally their pictures share, or someone is uploading. Otherwise, someone is a share like that. Those things are the concept and going to the this graph. But for that 10 to 19 age, the all are in the one column. So it's an age limit 13 to it's called 13 to 14. Age limit girls and boys are, but they're interested, share and like and comments.
Yeah.
So that's those things are I explained here, but normally in the end of the our analyze, all the ages are coming in 10 to 19 ages limit. That's why I explain and everything is adolescence influence of social media, those areas. In some countries, it's come around 10 to 18 age because 18 some countries are 10 to 21 plus like that.
Okay, apologies, it might be me, but that's still not clear as to why there's such a disparity between data collected and is this data collected by yourself or is this secondary data that's been analysed? Please.
Can you ask again?
Of course. So is this the result of primary data collection by yourself, this graph, or is this analysis of secondary
No,
data?
I got it. I got from one of the source. Source from the Google, and I got from the one of research fellow. So I forgot it the time that fellow name. So I'm really sorry. I think that those things have happened, and I got the research persons through the Google. I download and upload here.
Thank you very much. I think you've got a really interesting research area there. It just needs a little bit more development and honing, but I think you've hit upon something that could be very impactful.
Okay, thank you very much.
Thank you.
Can you hear me? I'm going to end off with a nice, easy question for you. As you know, there's a lot of debates about, and this is going back to law, about legal regulation of social media companies, certainly in the United Kingdom and the United States, about whether you should have a strong regulatory authority. And clearly this will have an impact on the area you're dealing with, because you're dealing with abuse of adolescents and the impact this is having. The times that we live in, there's so much information. There's never been a time of so much information on the web, on the social media. But there's also a time of so much misinformation. It's the greatest time in living history of misinformation that is spread throughout the world on numerous topics. Do you support, within the Sri Lankan context, of stronger legal regulation of social media companies that operated in this country, which would have an impact on the issues you're discussing and would contribute to, for example, less abuse and things like that? Thank you. If you could just answer the question, if you can, just a general question, please. Okay, do been asked to paraphrase what I just said. Do you support the regulation of the social media companies in Sri Lanka? Stronger legal regulation?
Can you explain because I couldn't hear the pronunciation. Can you?
For example, in the United Kingdom, there's a discussion about, people posting on Twitter, for example, racist abuse. And they're like, and also in your context, like, procurement, all sorts of things in terms of adolescents involving in sexual activities. Clearly that's an impact of social media, as we were talking about. I'm just saying that the social media companies have a responsibility to not promote these things, but there needs to be a strong regulatory legal body. And I'm just wondering if you support stronger legal regulation of social media companies in Sri Lanka.
Yeah, yes. Sure.
Will you be able to ask the question? You can ask the question.
Yeah, I'm very strong with my statistic and every comments. And the social media meme is not a Google. So there's, I've already said, the social media, more than 60 apps is there in terms of the social media. So I'm not clear with the question, even I can say.
What he was like referring to, like you were speaking about social media, right? I mean, it's true what you said, but the question raised is like, I mean, we have companies, who entertain these things. So what he raises is that, are you, suggesting any legal recommendations to stop all these abuses or things that's taking place in Sri Lanka? So do you have any suggestion to stop all these, ill activities for children that you have said between 10 to 19, you said, to stop these things, all these sexual activities.
Okay, that's a great. So these things, when I joined youth representative in youth parliament, and I suggest to our Prime Minister, because suggest that, so we need to include sexual education in subject of their study books. One is in that age limit, because they are thinking we want to expand the sexual subject or sexual abuse, the explanation or any study text we want to give after A level or O level, but that's not, because they know that after O level, it's mean after 16 age or 19 age, they know everything about the sexual abuse and what is the sex, what is happening is the moral and what is the physically, mentally, they know about it. But that particular age, 10 to 19 or 10 to 18 or 17, that people don't know about it. So we want to explain through the textbook to the schools. So we want to explain this is a digital world. So we are running in digital world. So we want to explain digital world how that return or how include in your life. So how you escape from that influence, social media abuse influence, not a social media. I'm telling abuse in goes like that, because so many things have happened. So how to escape, so how to behave, so how to handle it. So they want to include that textbook, other thing. Second one is, so the parents. The main point is the parents. So they went to some places, it's like coastal areas. The parents are went to foreign, then abroad for the purpose of their work, but children went to their grandmother or living in alone, so many things. So those children, 28% according to the research, they are abused with that the home guardian person. They don't know about the sex, but they did. The age before the 18, they are not still, they are adolescents, the kids. In the case in police station, they are saying the abuse and so many things. So the case in finishing. So I am telling this here. First of all, we want to create the one solution for that abroad fathers and mothers. It's with parents. So we want to create. The government want to create. You want to stop this age limit of people is there in home. So we want to proper system at home. After that only they want to give the allow to go over the abroad. Otherwise, they want to get a permission from some in the DS or in the grammar like that. So we're going to get some like that. Other thing is, third one is, first of all, we can't explain those things to our adolescent kids. We can't explain. But we want to tell the message. So how will the message? We can't send the message to the phone. We can't send the articles. We can't do it. That's all the responsible to go our society, leaders, and parents. So we want to get we have some idea. So I have some idea. So those things that we want to teach or anything we want to give those parents. So that is the best way for that. Other thing is the parents should be restriction for the mobile, and they want to give that. So how to use? They want to stop there, and like so many instructions there in social media, so they can stop and they can give that phone.
Right.
They can do it.
Yeah. Okay. Thank you, Ami. So he's got a hot topic, I think, but we want more details and more information to go in. Thank you for the presentation. Right, so we conclude the presentations of the papers, and we are now coming up to the awarding ceremony, awarding the presenters. So I invite Dr. Jonathan, and our chair, Mr. Shane, and Dr. Pinto, and Ms. Allison. Right, so may I call upon the first presenter, Dr. Ernest Fahim. Mr. Devan Shivantapiris. Mr. Samir. Yes, may I call upon Dr. Jonathan to present the memento to our panel chair, Mr. Shane Portner. Miss Anushka Ilakusinha. We have a best presenter award. We'll be doing at the end. So stay tuned, as in when we conclude the two sessions, we'll be nominated and we'll be announcing the best presenter for the session. Yeah. So we'll be off to lunch, and all of you should be here at 2 o'clock.
Mic testing one. Mic testing one. Mic testing one. Mic testing one. Testing one. Testing one. Testing one. Testing one. Testing one.
Good afternoon, all of you. My research topic is the draft counter-terrorism law in comparison with the prevention of terrorism. First of all, what is terrorism? Terrorism is the unlawful use of force or violence against person or property, intimidate or cause a government or its citizen to further certain political or social objectives. Let's take an introduction. Next slide, please. Next. The concept of human rights has been the core of the democracy which has been developed over the many decades. In every stage, the concept of human rights have undergone changes in response to the revolution and demands of the people within a given country. At such an instance, some countries have ended up in enacting law which becomes inconsistent with their own as well as international terrorist inventions. And well-being of the people. In human history, human rights are again through revolution, against anarchical, against a discrete. In each and every hour, these rights have been developed in order to ensure life of the people.
There are various international and national legal frameworks set out to protect human rights. The 1972 Constitution at the first time contained the Bill of Rights, which included both civil and political rights. The fundamental rights cannot be violated by anyone, but in some circumstances they can be restricted for national security and for the perfection national integrity. Public Security Ordinance and Emergency Regulation. That is in 1947, the Public Security Ordinance was brought in order preserves public security and maintains the public order. Under this law, President may make any order, regulation if is responsibly believes some committed acts which respectively immediate dangers to public security and public order. However, the emergency regulation under the Public Security Ordinance were not explicitly permitted part law evidence. The Prevention of Terrorism Act come only in 1979. Until the government had depended on Public Security Ordinance and emergency regulation to suppress terrorism and terrorism-related activities. Under the Public Security Ordinance, President will express his dictionary power to declare the emergency regulation under which suspected person could be arrested and investigated. Under the Section 6 of the Public Security Ordinance, this order or regulation made by President shall prevail is if there are any constitution with other existing laws. Now look at Prevention of Terrorism Act 48 of 1979. The Prevention of Terrorism Act became as a permanent law in 1982 deal with the combating terrorism and terrorism-related offence, and it limited of the power of the court to invest against the action of the state relation fundamental rights. When the government brought the Prevention of Terrorism Act, no chance was given to the Supreme Court to review the constitutionality of the peace legislation. Section 6 of the Prevention of Terrorism Act provides a new procedure granting power to public officer to search any permission or arrest any person if the police officer responsibly believes that suspect it committed the unlawful activity. Under the normal procedure, an arrested person shall be produced before the court within 24 hours. But under the Prevention of Terrorism Act, a police officer is given power and detain and arrest a person for 72 hours without being prosecuted by court, and no requirement to provide specific reasons for such blunt detentions. The legal framework, human rights law and counter-terrorism measure in order to protect the human rights of the citizen. The modern state have developed the human rights protection mentions the fair procedure for criminal justice system and the fundamental rights chapter under the Constitution. The state also become bound by various international conventions and obligations regarding human rights, especially after the establishment of United Nations organizations. The concept of human rights has become more permitted, and any human rights violation and couldn't happen country may be questioned worldwide. On the other hand, the international conversation which being countries demand and enacting legislation and creation of the related machinery to preserve human rights. Regional bodies on country terrorism mission is counter-terrorism treaties have been adopted by original substance and other state groups with the same aim of United Nations. Additional protocol of the South Asian Association for Regional Cooperation has two provisions reference to human rights protection. However, the original convention will give emphasis of human rights. The protocol is not being interpreted as affecting the international humanitarian law and international human rights law. The Inter-American Conventions Against Terrorism mention that the measure to suppress terrorism should be taken with the respect of rule of law, international human rights law, and international humanitarian law. The Council of Europe also has adopted the European Convention on the Superstitions of Terrorism in 2002 with respect of human rights protection. My conclusion is, in Sri Lanka history, it is said that the anti-terrorism law were brought to combat extreme in every stage. However, with the introduction of the emergency regulations under the Public Security Ordinance and the PTA, serious human rights violations had been noted, while it claimed that it only an attempt to suppress the terrorism and terrorism related often in the country. Thank you.
Good evening, everyone. The Q&A chapter is open now. If you have any questions, please you raise your hands. Yeah.
Yeah, thank you.
நடந்தது சொல்லுங்களேன். டேபிள் வரைச்சா பார்க்கல, டேபிள் புதுசு வாங்கி கொடுக்கணும். எவ்வளோ சொல்கிறான்னு தெரியல. இது வரைக்கும் இத்தனை வருஷம் நான் வேலை கூட
He's ready? He's ready. He's joining us online, right? Next we have Mr. Tushikanthan S, who's doing his research, who's discussing his research topic on freedom from arbitrary arrest and detention, critical overview on the recent reforms on prevention of terrorism, temporary provisions and amendments to the Act. So he'll be joining us online. Yeah.
Yes, brother.
Hello. You can start the presentation now. Can you hear me? Did you hear that? Did you hear that? Did you hear that? Or just send a message to me?
Yeah.
Can you ask him to send a recording?
We're facing a sort of a technical challenge here, so kindly bear with us for 5-10 minutes, please. Thank you.
These things happen. These things happen. The internet can go down all sorts of things.
I'm pleased to extend my good afternoon greetings to all gathered here. I would like to express my sincere gratitude to everyone who made this movement for me. My name is Ikan. Under Pension Amendment number 2022. Introduction. Human rights are based individual rights. Human rights are maintained They were recognized and for arrest and details. EDA has stated that the purpose of preventing terrorism, that then it is used for unlawful detaining, brutal harassment, torture, politically motivated arrest, and racist revenge over the past years. Arbitrary arrest and detaining are not accepted under international legal obligations. Prevention of the Terrorism Temporary Provincial Amendment Act number 12 of 2022 has been introduced to enhance the protection of such detainers. This mainly introduces a new method of approaching the magistrate within 48 hours, and the officer in charge of detention need to serve the detention order to the magistrate. However, the new amendment failed to address the key issues in the law. My research question: why do illegal arrests and detention continue to occur despite the existence of both local and international laws on preventing such action? Even after the amendments were introduced to the Prevention Terrorism Temporary Provincial Amendment Act. Methodology: qualitative, strict and qualitative strategy, primary data collection, secondary data collection as well. Originality of the contribution: freedom from the arbitrary arrest and detention is also dominant right, which was infringed by the human rights activities worldwide. Legal arrest and detention mean arresting or detaining individuals by not knowing the method under the law. The Sri Lankan Constitution and the criminal procedure have ensured both rights of freedom from arbitrary arrest and detention. The Prevention of the Terrorism Act deviates from the general routine and remarks dark stains on human rights mechanism. The Prevention of the Terrorism Act is interminably criticized over the decades. This legislation considered as political weapon is used to hunt their antagonists. The PTA is used for unlawful detaining, virtual harassment to torture, politically motivated, arrested, and raised offenders. Some of the cases are examples for that. Jail-based cases, Latif Nuarania, Inspector of the Police, and Says AG and others, Mohammed Faisal, Appointed General and others. Findings, international remarks on the topic. International Court of Justice in relate to the arbitrary arrest of lawyer Pages Hezbollah commented that Sri Lanka has a duty to protect such rights at international level. Analysis of the old law, the practice of arbitrary arrest and detaining is normalized. The Act itself presents contractive laws that conflict with human rights. The officers in higher ranks perceive it as a normal. Analysis of 2022 amendment. No changes were made for the most demanding laws. The new law has amended the detaining procedures. One is attorney visitation, another one is filling an indictment and bail also. Analysis of 2022 amendment. Human rights deficient provision in PTA remain untouched. Admissibility of convention in detention which officers can use legal it explained by Meridas of the state. Under indications on the definitions of terrorism are also not set out. Most amendment incidents show that continuous abusive practices through the PTA. Conclusion: the new amendment hasn't addressed the dire parts that need change. However, there are some changes that have been suggested in relation to attorney visitation and bail. It should be noted that the Act is still being used for unlawful arrest and detention. Thus, activists must continue to fight for their basic human rights. Challenges and implications, legal ambiguity and implications, acting secretary and civil liberatory, international comparisons and human rights standards. Limited access to the data and information, critical, sensitive and controversy, legal and ethical constraints, based and subjectively. Advantages. Increased understanding of legislative reforms, gaining insight into the recent amendments and their implication, evidence-based policy recommendation, is providing the foundation for informed policy, decisions and potential reforms. Promotion of human rights, identifying areas where the protection of human rights can be strengthened, accountability and transparency. Other advantages, international engagement, strengthening the justice system, promoting social cohesion, protecting of the minority rights. Disadvantages, access to restricted information, so limited availability of the sensitivity government data and documents, political backlash and opposition, so potential resistance or pushback from the authorities or groups, safety and security risks, so researchers may face risk due to the sensitivity of the topic and potential penalty. Thank you.
Do you have any questions? Right. Anna, do we have any questions from the presenter?
One general question. Oh. Can you hear me?
Yeah.
Yes, so as far as your topic is concerned, it looks like you're against all strict liability offenses. Is it the case that when you say it is arbitrary, how do you define what is arbitrary? I might not go much into it. I'll first stick to the first question. Are you against all strict liability offenses? And is that coming out in your paper?
That it's about the arbitrary arrested that nowadays it's very big issues, and that previous amendment was not clearly mentioned to protect the human rights.
Okay.
Hello?
Okay, so did you also look into this side of the stakeholders, which is victim perspective, when you did this research? The victim perspective, not just the accused perspective, but the victim perspective of how this arrest could be better for the larger interest of the society.
So if any person involving in the arbitrary arrest, we have to in front of the magistrate court he have to attend, and some of the bail procedures also have to changes or modify to supporting to that if that person didn't do any wrong.
Got your point.
So
I
we
think
have
you've not understood my question, but it's okay. Probably there's a communication issue. My question was not this. It was about whether you first thing, what is arbitrary when you say it is arbitrary?
It's a illegally that arrested. It's against for the human rights.
Everything will be against human rights. Even an accused would say it is against human rights. A person who's guilty can say it's against human rights. Well, how do you define arbitrary? Have you got into any kind of method? Did you apply any method to find out if there was any arbitrary arrest with under that legislation? Are there any factual examples?
If sometimes any brutal harassment or unlawful detaining activities or politically motivated arrests or racist vengeance are related with that.
Okay, thank you. Probably you're not getting to where I want you to. That's okay. So yeah, thanks.
Hello. Can you hear me? Can you hear me? Can you hear me or not? Can you hear me? I'm not sure if you can hear me.
Can you hear Dr. Ze'ev?
Yeah.
Okay. Just following on the question from my friend and colleague just now. Obviously, in terms of human rights, there has to be a balance between the protection of the right to life. Okay. All right. Let me put this on. Can you hear me now? Okay. Obviously, I think what my colleague. Can you hear me?
Yeah.
Okay. I think what my good friend and colleague was just getting at just now is there's obviously a balance between different human rights. For example, the right to life and the freedom not to be arbitrarily arrested. Because the first role of any government is to secure the security of their population, to ensure that no terrorist act is committed against their population. I'm just wondering, where do you draw the balance? For example, in the United Kingdom, you can be, if you're suspected of possible engagement in terrorist offences, you can be detained for up to 14 days without trial. Where do you think the balance should be in terms of Sri Lankan law?
The Sri Lankan law, it have to change in the amendment, and if most of the things are in the PPA have to change. It's against the human rights, some of the activities.
If I may come back on that, I don't think you're answering the question. I think it's more to do with the fact that, you know, obviously a government's concern is about terrorism. God forbid someone who walks into a hotel and blows themselves up. That's what the government's concerned about is. And sometimes the government has to take action to prevent that happening. And that's why I said in the United Kingdom, you can be, if you're suspected of possibly going to engage in a terrorist offence, you can be detained for up to 14 days. Where would do you think there should be a similar policy in Sri Lanka? I mean, obviously not 28 days, but maybe 14 days. Someone could be detained and questioned, because one of the reasons why people are detained is because they need to go through people's computers to get the information, the relevant information, before they actually charge somebody. So you didn't answer the question as what you define as arbitrary. And secondly, do you think there's a balance in terms of human rights whereby, you know, sometimes the security forces have to take necessary action to prevent a terrorist offence? I don't think it's an answer. Yeah. I know what he's trying to get at. You shouldn't be detained arbitrarily. We know that. We agree. But sometimes you need to detain people.
Individual rights.
Yeah. I mean, it's also the collective right, the right of society as a whole. So that's where he's getting it. But sometimes you need to take action to prevent a terrorist offence. The question is where do you...
of the nation.
Yeah, yeah. You know? Okay, that's final. That's my question. That's it, really. That's it. I mean, we have probably an interesting, we have a similar understanding in a way, because maybe partly due to our backgrounds, because although I live in the UK, obviously the UK has been affected by terrorism. India,
As much as India has
as well.
been.
And also, my mother lives in Israel, so we understand that. You know, so that's the thing. So yes, we have to, also support human rights, but it's got to be a balance.
We have to protect our nation.
You have to protect the people.
There's a duty on the institution, governmental institutions.
Yeah, I mean, otherwise they abrogate their responsibility.
Absolutely.
Anyway, let's see. You didn't. I don't think that was a very good presentation. What do you think?
Neither of these.
You want to ask a question?
The question, like maybe he doesn't understand.
Do you want to answer it? All right, you answer. You want to answer. Hello? I'm just passing you to my colleague. He's going to answer. A good friend of mine from Sri Lanka is going to ask the question in probably an much easier way, a more understandable way than myself.
So you're online, right?
Are you there?
It needs to have gone by now.
So the first question was, like, can you hear us?
Hello?
Yeah, can you hear us?
Yeah.
Yeah, all right. So the question was, like, the first question was whether you understand the difference between arbitrary
Arbitrary arrest and lawful
arbitrary arrest and the lawful arrest. So did you understand that question?
Yeah.
So the the difference, the differentiation, like, how do you say arbitrary arrest? So like, if you can explain it to her, then it will be wonderful.
Arbitrary unlawful detention, it occurs an individual is arrested and it's detained by the government without due process and without the legal protection of the fair trial, or when the individual is detained without any legal basis for deprivations of the liberty.
But the trial happens after the arrest is done. So fair trial comes later in the picture. Is he able to hear?
Yeah.
The trial happens after the arrest is done. Are you able to hear me?
Yeah.
So that picture of fair trial comes in later. How do you define arbitrary arrest before a trial is done?
In the lawful arrest trial is come through after that arrest a period of time, but in that arbitrary arrest it will take the time.
That's the difference.
Okay.
All right, thank you very much. So he accepts it as an answer. So there was another question from your end, right?
Yeah, it's mainly to the fact that sometimes you have to protect society as a whole. You need to arrest somebody, maybe keep them in detention for 14 days, and then release them. Because you need to collect the evidence before you charge them, especially in terrorism offences. So, for example, in the United Kingdom, you can detain somebody suspected of terrorism for up to 14 days before you bring charges against them. So it seems to be like saying you can't detain anybody. So what's his position? Where does he find the balance in Sri Lanka? Would you, if God forbid someone wanted to go and commit a terrorist offence in this building now, and had information, you didn't have all of it, how long did you think you could detain them before you could actually release them if there's not the evidence? It's a bit more complicated.
All right. Okay, his question was like the fairness of keeping a person in case of terrorism, and like like if the enforcing agency is suspecting the person for terrorism, like how long that person could be taken in, and like how long that can they keep him in custody? Like that was the question. So what's the fairness you see?
Asking.
We'll talk about the law, which is for 14 days.
14 days law, yeah. Like
in
you're
the
talking
UK, it's
about.
14 days.
Yeah. So in Sri Lanka, it's quite different. So how do you define it? Like what's the fairness of it? Like keeping a person for that long, and do you see it fair from your end? That was the question.
And in that case, he'll be against all strict liability offences.
I don't think we're going to get an answer. We can move on.
Sorry.
We won't get an answer. We can move on. I mean, there was a discussion in the UK to detain somebody once.
14 days.
Yeah, 14, but there's one
But
single
that's
discussion.
not the case in Sri Lanka.
How many days is it?
I think it's 2 days.
Are they?
So
that's not really enough, really.
Yeah. Do you have an idea about the period of detaining, like how long it happened? So how do you compare it with the UK and Sri Lanka? If you can elaborate more, then they might get a proper answer.
The woman is lawful arrested within 24 hours. They will attend the court, but in the arbitrary arrest them under the investigation period. The Sri Lankan government is taking the time for investigation.
24 hours is the normal arrest. Normal arrest takes about, the person has to be produced before the magistrate in 24 hours. That is for a normal arrest, not in these terrorist acts and narcotics act, etc., where the police can detain them for more than 1 week. In fact, some of the countries are 14 days. That's the norm mostly. UK, India, etc. So that's what. So what is the period? If you have seen the legislation, have you studied the legislation? Have you seen the legislation which you're speaking of?
Like 6 month period.
Oh, I think you'll have to go back. That's the entire trial. You're talking about the trial, etc. We're talking about the detention period. Okay, that will not extend it more. I think we are done with the questions.
All right. Thank you very much. Thank you. That's it.
You see, for a normal, if I'm about to commit, suspected of committing a criminal offence, they can detain me up to 96 hours.
Explain it to the audience, and we can
maybe later.
That will be better.
What now?
Yeah, please. Yeah.
Okay.
Come to UK and like how can we improve?
And if you've seen India.
Can you all hear me? I've just been asked to explain the premise of my question. If somebody, for example, is suspected of committing a burglary or robbing a house in the UK, they can be detained up to 96 hours. Obviously, they have to get the permission of the magistrate. They can be detained for up to 96 hours without being charged by the police. The reason for that is they need to look at the evidence. Sometimes it takes a long time to get all the evidence, but for a normal crime, for example, if somebody was going to burgle a house or to rob a shop, and they haven't done it, but they've got suspicions that they're about to do that, or they have done it actually, they can be detained for up to 96 hours with evidence. In cases of terrorism, if there's a suspicion that somebody is about to engage in a terrorist offence or is about to engage into a terrorist offence, they can be detained for up to 14 days before they're charged. Because clearly there's two offences. In criminal law, for example, there's a conspiracy to rob a house and there's actual robbery taking place. In terrorism, obviously there's a conspiracy to commit a terrorist offence, or if God forbid that someone's committed a terrorist offence, then obviously you charge them on that basis. But you can be detained for up to 14 days on suspicion that you're about to commit a terrorist offence or have committed a terrorist offence without being charged, to enable the police to get all the evidence together. For example, we live in as we said this morning, we're talking about technology. Sometimes you need to decodify cryptic messages in computers to get the evidence, and that takes time. And so there was initially a discussion in the United Kingdom about detaining terrorist suspects up to 90 days. That was seen to be too excessive and a real attack on human rights. And so in the end, it came to 28 days, but now you can detain somebody on suspicion of possibly committing a terrorist offence, or if they have, for up to 14 days without trial. And that was the sum of that was the crux of my question. And what is the situation in Sri Lanka, basically? Does that explain it?
Yes.
Yeah.
That's good differentiation.
Yeah.
Sri Lanka is different.
What's Sri Lanka?
It's 24 hours.
Yeah, I'm surprised because I thought
Even in the terrorist
terrorism.
provision. So the normal is 24 hours for any suspicion.
It's surprising.
We can ask someone in the audience.
They're
Do
all
you
lawyers.
ask somebody?
Yes.
Do you want to ask somebody?
Except to make some.
Okay, all right. Okay, shall I ask them?
Yeah,
all right. We
You want to talk?
we'd like to.
They can keep 3 months.
Okay, do you want to explain? I've got a colleague here who's a law academic from Sri Lanka. Come over here, sir. Sir, come over here, sir. He's going to explain to you. I'm not an expert in Sri Lankan law and in English law. He's going to explain to you the position in Sri Lanka in terms of detaining terrorist suspects.
Yeah, once a person is arrested under the ET, Police Intervention Act, or this regulation, the person can be detained 3 months. And after completion of 3 months, the person can be brought to the attention of the magistrate, and then thereafter can be extended to further
up to
3
6
months with the
months.
Secretary of the Ministry of Defence. With the permission of the Minister of Secretary of Defence, it can be extended further period of 3 months up to 1.5 years.
That's a similar law in India.
Yeah.
So, if I may just comment on that, it seems in that sense it's much more draconian than in England, because in England you can only be detained up to 14 days and then released. You're saying in Sri Lanka you can be detained up to 90 days, 3 months, without being charged. Is that correct? So it's much harsher in Sri Lanka than it is in the UK, where you can only be detained up to 14 days. As I said before, they did want to extend it to 90 days at one time, but they said this will be a tremendous breach of human rights. But you've got the 90 days of Sri Lanka, unfortunately.
Before 90 days, you can go up to 1.5 years.
So what you're saying is even more draconian, that you can actually detain somebody without charging them for 1.5 years if they're suspected of. That's a long time to be detained without being charged, 18 months. And that will be defined in my book as a clear breach of human rights. Yeah.
So, are we done?
Yeah, he said like 2 days.
I think it's okay. I think he has not seen the text of the law.
He did. I don't think he's even read the legislation.
He showed the legislation.
But he hasn't read it. Because you asked him.
Yes.
He didn't
Probably
read
got confused when I was. They are backing him. So
What's that?
the organizers are backing him. So
Yeah, I know. It's good. It's nice to give him more.
it's a good story, probably.
I have the name.
So should I get up?
You want one more?
One more than 2.
Should I get up?
No.
You said these are the 2 ones.
What's the law in India? 14 days.
It's similar to how it is in Sri Lanka. Initially, they arrest for 14 days, but then it goes up to 3 months, and then it can keep extending.
But you have to have a say so with the magistrate.
No, it's, yes, before 14 days.
Or after, or have 14 days.
No, within 14 days.
Mr.
there should
Divakar,
be a
can you
written
hear me?
Order that this person has been arrested.
Mr. Divakar, if you can hear me, can you just say yes?
Because they have to bring charges after 14 days in the UK. Otherwise, they have
Yes,
They
I
have to
can
make
hear
a
you.
charge.
Hear you. Like, give me a moment and like load up the. Yeah, can you hear me?
Otherwise, you're
Yes,
released.
yes, Mr. Divakar, I can hear you.
All right, great. Okay, cool.
They have to charge.
There are many offences like Tada, Puta, etc. in India, which have different time periods. So there's a little.
I mean, terrorism is very serious in India, as you know. It's a serious issue.
It is.
You get some,
But then we follow the due process, and
Yeah.
the victims are always ignored.
that's a
Talk
problem.
about war and peace.
Yes.
So, the topic is about Vista's global human rights.
Hello. Yeah, go ahead. Can someone confirm that they can hear me very well, please?
We can hear you, Mr. Divakar. We can hear you properly.
Yeah, thank you.
Right? So I will
Yes.
I will just do a small introduction about you, and then you can start. Yeah?
Yes. Good afternoon, everyone presented over here. Thank you, everyone, for the opportunity that they have provided for me. Well, I'm Divakar Prakash, and I'm an undergraduate from the Animation Campus, Sri Lanka, currently following the 3rd year of Law LLB, Bachelor's of Law program. And my topic over here, my discussion over here for the conference today is War or Peace, Vistas Global Human Rights and Rights Law and Humanitarian Interventions.
You got the paper?
Yes, Mr. Divakar, you can go ahead. Yeah, I have done the
I've got
introduction.
it.
I think this is not mine.
I told you to go ahead. Mr. Divakar, can you hear me? Mr. Divakar, can you hear me? You can go ahead. You can continue with the presentation. We're facing a small technical issue, so he will join with us in about 5 minutes, maybe 2 to 5 minutes. Thank you.
The conference has
So
gone well.
it's 30 days in India now. Like I
It's
just
gone
checked.
well. And what did you say?
So it's not 14, it's 30 days.
But, and then you have to be charged.
Initially, in the Narcotics Act, it was 14. There are various legislations which don't call for a men's
Hello, can someone confirm that they can hear me, please?
Yeah, we can hear you, Mr. Divakar. You can go ahead. Thank you.
Yeah, yes, I'm sorry about that. Yeah, let me share these slides for you. There you go. Can someone confirm that they can see the slides as well, please?
We can see the
Hello?
slides. We can see the
All
slides.
right, cool. Thank you. Thank you. Yes. Yes. Good afternoon, everyone. Those are presented over here on this very occasional day. And I'm Divakar Prakash of the IRCLAW International campus, an undergraduate of the third year. I'm going to take you all through my discussion on war or peace, discuss global human rights, law, and humanitarian interventions. So just before we move into my discussion, let me give a small idea of what my topic really is about. So this discussion or the paper speaks of the balance between the human rights and the human rights interventions that has been taken under many various occasions in the global throughout the occasions for the time being until now. So it's the time I'm unable to take you through the entire discussion under the provided time for today, but let me try to take you through the entire session in a summarized form. So let me take you through the first slide, asking you a question or letting you all to think about a few questions on that shown over here. Yes, and you could see there are a few questions that we could ask ourselves in world today. So regarding the human rights and human rights law. So you can see first and foremost, when someone asks us about what is human rights, we could come to a small idea on it is a right that every human being or every sentimental being that is bestowed with our born in this world here, which we are living today. Okay, yes, that is a good answer. We'll come to the conclusion. But when we look at this, it is the fundamental right that every human being is having along in our world today. So I believe that the human rights and the freedoms, the core beliefs, the values that bind the entire human family together, and they form as the only truly universal language on earth, acceptably, or maybe sadly, perhaps so often for war actually. Yes, so these rights and freedoms were hard won all over the world, we know, in various occasions and in many parts of the world. And they are yet to be realized in some part of the world too. So in other parts of the world, including here, in Europe, in UK, even in London, these rights are currently and constantly under attack in various forms. But they were agreed by previous generations to sense which the generation lived before and among the 19th century, not the one we are currently living on, but They had faced the horrors and the terrors of the Holocaust and the plagues and the horrors of the world during those World War II. At a completely unique moment, yet to be repeated in history currently now. So we all know that in our planet Earth today, people slightly biased on various topics and policies, such as the democratic policies. People belong to the left, and the unaligned people representing all the great world religions, and people with no religious conviction whatsoever. They came together and they all agreed on essential of civilized society and what it would take, and what it would take was not constantly and forward to descend into barbarism and war. So then the birth of a very important declaration was born as a result of so many wars and violence that resulted in the world, which was the Universal Declaration of Human Rights, which replicated in regional instruments all over the planet in various forms of different institutions, which gave us a really good law and which was made into an accent upon various instances, and such as in UK, the Human Rights Acts. And yes, it is under attack constantly by various forms of actions and behaviors of the human. So what's at stake? What's at stake at this world which we're right now? What are these things? What are these rights, freedoms, and things that I hold dear, that you hold dear? What are the human rights that protect you and your family and your friends and your neighbors and everybody else in this world or the earth that should protect every newly arrived baby to this world? Yes, not just before they are alive, not because they're a good person or they're a bad person or a taxpayer or a wealthy man or woman, that should protect every single one of us based on this basic necessity of right to life. So this brings us to a different area of what the human rights and what do they hold dear of. So we do know that every single human beings are bestowed with the rights, freedoms, protection, thoughts, and the right to life and the right to speech. These are some few basic necessities of the human rights that we'll look into. Yes. So let me take you through the next part of my discussion, which was the human rights law. So we do know that what a law is. Law is something that we define that it is followed uniquely and independently without any other inflictions or any discrimination to every all sentimental beings. So that comes to the human rights law, which was followed by the United Nations deployment of UDHR, which is a United Declarations of Human Rights. So then we all know that we can all think of that. Why is this law important? Why is it important to us in this day-to-day life? Because we are all busy with our life in day-to-day, and at the end of this new born century, we'll think every single terms of the monetary value, and we are running a rat race behind something or another. So we can come to the conclusion that these are really important when we look into or when an escalation rises in any part of the world. It can be in terms of war, it can be in terms of any discrimination or any instance where the basic necessity and right is being neglected for any person. So I'll try my best to take you through the entire discussions summary in my speech over here today. Yes, sorry. Okay, so let me take you to the take a small question on what you will think about. How can you have fair elections without a secret ballot? How can you have a healthcare advice without medical confidentiality, or a fair trial without confidential counsel, or so on and so on with some confidentiality? So you all can think about it and take this thought with you all to home on privacy that we are living in our world today. Can the privacy be breached by certain activities, and that can that be inflicted in our human rights, and how can that be inflicting on our basic breach of right? Okay, so let me take you through over here into the next slide of the contents of my discussion. So it speaks of the human rights law as the beginning, on which acts as a law with the protection to individuals or the groups or the unique bodies against violations by governments or any international guaranteed rights when it is breached over with the promotion of these rights. So, and they're protected by certain acts that they are looked into upon each of every certainty. And let me take you to these contents of the human rights law. It's just a small basic content which I came across and which I have included in my discussion. And obviously that is a really way more deeper and understanding in my paper. So it includes of speaking or the speeches of the Declaration of Human Rights by the United Nations and then the Charter, how does it follow and how does it understand and how does it act upon in the basic necessity. And it acts upon in using the few international covenants on civil and political rights, and also the economical, social, cultural rights too as well, by acting various different ways of actions throughout the entire time being. It also acts as specific human rights and treaties and regional human rights and treaties as well. So when we look into various different countries and nations, so that is going to inflict and that's going to have an effect on the state sovereignty of our nation, of the most nations. So, and also which brings us the customary international law, following the domestic and international law abiding to that. And which brings us to conclusion, what is humanitarian and what is a humanitarian law does over here in our day today. So we all know that every part of the world has been facing and has faced or come across a certain war or any violence in the history. So we know that how that has been inflicted in our day-to-day life and the future to come as well. So that brings us when that human rights has been when that human rights has been breached or there has been there's been breach and there's been a considerable damage done to it, the humanitarian law comes in effect. So which acts as a law in protection of the affected human beings, and it can be not only for the human beings, it can be also for the I'm sorry, can someone
you can go ahead.
Confirm that yes. Okay,
we
all
hear
right.
you.
Yes. All right, yes. So in addition to the human rights law discussed above on these previous occasions and special and certain instances, the protection of the victims during the periods of armed conflict, this body of law is reflected to as an international humanitarian act and law, which is a branch of the international law, such as so many instances and institutions would involve in protection of this. Yes, let me take you to the few implementation of how this humanitarian law has been viewed and progressed throughout the past time being. So it is the beginning of the Law of Geneva. So where the protocols on safeguarding civilians, wounded or the sick and captured and many more, which was included in it on how an army or and nation should reflect on people when they have been faced or inflicted to a war. Okay, and that brings us the law of Hague following it, which determines the rights and duties of belligerents in the conduct of operations and limits the choice of means of doing harm by protecting the humans. So, and also there have been so many involvements of International Committee of Red Cross throughout the globe, which helps in development, implementations, and monitoring the humanitarian law in various activities, such as protecting the human's basic necessity without any bias. Okay, and let me take you to the very important part of the United Nations, the Security Council, which the people we all know about and speak a lot about. This is a council which is one of the 6 principal organs of the United Nations and is charged with ensuring the international peace and security by following certain rules and regulations upon a rise in the conflict or an act of conflict. Yes, and we all know that when an act of breach or a breach of the human rights has occurred or taken place, they are all brought upon the law and made justice upon them. So, and justice is provided for those who are affected. So this is one of the important code which decides the international regulations and the acts that happen across the globe, which is the International Criminal Code, that is an independent judicial body that overlooks the international criminal acts that happens throughout the globe. And we all know that there are certain consequences and yes, there's certain consequences that happens due to these interventions and actions. So we know that United Nations tries its best and foremost to prevent any escalation, but in case of an escalation, they do have many more ways to resolve them as well. So operations of United Nations Security Council decides on how and what to happen in case of such instances and tremble. So let's say when a state's sovereignty is under attack by any escalation, that can result in state sovereignty. And also there can be casualties around both sides of the groups and parties, and which resulting in political asylums of the political people, and it can be of the basic or general civilians too. So this brings me to the conclusion of my slides over here. Let me give a small idea on what furthermore my disposition speaks of. So it is as academics, we call it as non-discrimination, where there's a really important word which we academics call it as non-discrimination, which can be translated to just basic human language as empathy. So empathy, which is treating other people as you would like to be treated yourself, walking around in someone else's shoes, and it can be called etc. just like that too. So we can find, or you find the germ of this idea in every great civilization and tradition on earth. Why we can ask ourselves a question: why is this the most important? Why is the equal treatment more important in my view than torture and slavery and free speech? Because if we practice empathy, there would be no torture, no slavery, no incarceration without charge or trial, or undue interference with speech or conscience, and so on. Because whatever they say, whatever powerful interests and bigots and hateful people tell you, they all love human rights. They all, yes, they do. We all love human rights. I hope we all do. And I think various heads are being nodded for that question. Yes, and our own and those of family and friends and the people that we identify with or we relate with, we do all love them as well. It's other people's right, and they're a bit of problem when it comes to some certain other people, but yes, they are considered as humans. Right now, my speech over here is free for you all, but I think it is a bit more expensive for the time being for your time. And I promise that it won't take much longer, and leaving you all with a little bit of a question to ask for yourself. So let's consider the Europe and all over the world in early part of 20th century. So, and ask ourselves the same question: which of these rights and freedoms would you give up, or which of these trivial, unnecessary superfluous which you would give up for the cost of the human rights? What would you give up for the cost of the human rights? There may be some who would choose to live on the planet, but that can be costly for them too. Yes, thank you for your time for listening on my discussion, and I hope you go through the discussion, and that will take you through a vivid and interesting part on how the nations and the United Nations around the globe and the humans and the civilians are affected, benefited, and which is continuing through the entire civilization, and which would continue to thrive through the civilization to come as well. And I end my speech over here with the note that the law is the art of equity and goodness, which is equal to all. Thank you for your time. Thank you for your. Yes, thank you. Hello.
Yeah, just stay connected because they might have some questions, right?
All right, cool.
Right. The Q&A chapter is open now. Do you have any questions?
we have a question, online question. Can you hear
Okay.
me?
Yes, I can hear you.
How could discrimination would be empathy on simple word? Did you get my
Could you
question?
repeat that, please?
Yeah. How could discrimination would be empathy on simple word? How could discrimination would be empathy on simple word? So someone is asking, discrimination.
Okay, yes, it would be better for that person to relate that to incident, please, because the discussion. Can someone repeat that again, please?
Yeah. So he is asking whether discrimination, like it's a sort of a different question. Like he's asking whether how can you relate discrimination to empathy?
Okay, let me repeat the question to get if I'm correct on that. So the question is how can we relate, or how can the discrimination be empathy?
Exactly.
Okay, so those are two. Let me take you through those two terms actually. So empathy and discrimination are two opposite terms. So empathy is the thing which comes out of when you, let's say you treat yourself. Let's say you wanna benefit something for yourself, and you treat the same way to the person in a positive manner, not in a negative manner. But let's say discrimination is in a negative way. It's a negative way. Let's say, would we allow ourselves to discriminate or do something to ourselves that would be harmful or inflicting to others, to us? I'm sorry, to us? No, we wouldn't do that to ourselves. Just in case of that, if we are, let's say, not unable in our mind, yes, we would do something like that. But if we are in our mind and clear, yeah, we wouldn't do something discrimination or anything harmful to us. So, but let's say discrimination, you deprive someone's or others' right. So would you deprive your rights? No, that's the basic necessity which comes upon the human's nature. Not just humans, it is applicable to the animals too. So when you are deprived of something, you would revolt back. So we can't discriminate ourselves, or that's not possible, and we wouldn't. And so we wouldn't discriminate others. Empathy is something that you show to others, or let's say how you would treat yourself, the same way you would treat others in a positive manner, not in a negative manner. I hope I'm clear.
So I think the online question was about that. So any other questions?
Okay.
Thank you for your opportunity. So, are you believe in human rights affect to the every single country, except third world countries? You talk about war. I can bring you the past Chechenian war, 1994, 1996. Are you believing human rights affect to the other countries as well?
Okay, can I ask you a question on that regarding that, if you don't mind, please? Yeah, am I audible? Hello, am I audible?
Yeah.
Yeah. So can I ask you a question on that? Yeah. So is this question about that particular war, or are you referring to the human rights on every part of the or every countries? To be precise, the third world and the developed or underdeveloping countries.
That's why I said except third world countries. I'm talking about developing countries.
Okay. So you're talking about developing countries, and are you asking that are they common to those countries too?
Yes.
Yes, it is common. So the basic, because the human rights are the fundamental thing to every sentimental being on this earth that's been born so far and to come as well. So let me just say about war. Since I might, it might have confused you looking into the topic of my disquisition. So the topic of the disquisition is just giving you an idea, war or peace, and that's vistas. So let me give you an idea what the vistas is. It is a pleasant view. Let's say you climb the top of the mountain, you have pleasant view. Okay. Could you confirm that? You can hear me, please?
Yes, yeah, we can hear you properly.
Yes. Vistas, like the word vistas, that means in Roman terminology that when you go to higher position after climb, you get a beautiful view from the top, right? So it's similar. We are viewing through a distance or a longer avenue through opening and a prospectus. So we are viewing through it. We're just looking at the balance between the war and the peace and how it has been happening throughout the globe. So when I come to your point that, let's say, the third world country and a developing country, let's say both of them, or any, let's say it's even applicable for the developed country, the frontiers as well, the basic necessity. Let's say when a person is deprived of the basic necessity, you kidnap, or when a person is shut inside a room for a few days and deprived of their food. So that can be basic violation of human rights. So it's not necessarily that there should be a war to make us understand that there's been a violation of human rights. There can be other certain inflictions or like instances too. And just like we all humans need food to live on our life day to day or continue our life. Yes, I'm sorry, I'm not a medical critic, but I'm just giving a small idea. Yes, we need food to live throughout. So just like that, basic necessity, a fundamental thing, that's a human right too. I hope I'm clear on your question. I just made it clear about that. Hello?
Sir, in what ways have humanitarian interventions influenced the resolution of conflicts and the restoration of peace in regions?
Okay, so could you repeat that one more time, please?
Sir, in what ways have humanitarian interventions influenced the resolution of conflicts in different regions?
Okay, the influence of the resolutions, is that what you are meaning?
Sort of, yes.
Yeah, okay. Let's say for the terminology, the United Nations has different covenants that acts on various regions of the globe, okay? So let's say the various most important continents, let's speak of continents, the African and the Asian, or not to be specific, the South Asian, and let's say the European continent. They do have different covenants. Like let's say it's sort of a committee which overlooks into the actions that has been happening and the actions that have been made or to resolve and for the betterment and what can be done to improve the betterment. So they overlook through these things along with the ICRC, the International Committee for Red Cross, the International Committee of Red Cross Society. They look over it and they finally gather about all the information and the outcomes of what has happened. And obviously they are passed on to the further actions that they would decide on new conflicts that to come. Yes, they do influence in various things. Just to add a note to that, we are all humans, right? We all learn from the past and the mistakes. Yes, it happens, and they are influenced too. Influence in terms for the betterments. Yes, I hope I answered your question.
Thank you.
Thank you.
So that was an online question. Again, we have another online question. Since majority of participants are Sri Lankan, let me ask you, what is your opinion about LGBTQA plus community rights? And should this be considered as a basic human right?
I'm sorry, you're breaking up. Could you repeat that one more time, please?
Yeah. Since majority of participants are Sri Lankan, let me ask you, what is your opinion about LGBTQA positive community rights? And should this be considered...
You mean? Go ahead.
Yeah. And should this be considered as a basic human rights as per human right points? Like, so he is asking about the LGBTQA rights.
Okay. So, yeah. So you're speaking, or the question is about our country, the Sri Lanka, yeah?
Related to Sri Lanka, yes, he's asking.
Related to Sri Lanka, yeah. So, okay, that's an ongoing topic in the country. Good question. So, yeah, the basic right to life, right to choose, and yes, right to thoughts, or it can be right to thoughts of religion, which they choose or which they which is like it's not just the religion or we are just limited to the religion. It's their belief. They are all their basic rights. So yes, when someone has their own perspective view on LGBTQ, like their perspective on it is correct and yes, they are rights of the human being. Yes, to the point of view of mine, yes, they are can be considered too, because every human being, those who choose to live on this earth, they have the right to choose and their right to life. So which is a basic necessity. So there can be complications when that particular notion comes into effect with or come into conflict with the religious terms. Yeah, that is where everything conflicts. But when we look into the perspective of the balance, let's say the balance, the law is about balance, right? So when we look into the balance of the good and the bad, the best and the better, and or the worse and the worse, so you can come to the conclusion that this is a basic necessity which a particular person or a community can choose. So if they wish to be a community of particular belief or following of their particular concept, yeah, they have right to continue that. I hope that that will get a better point of view in future too.
Yes, as you said, like, most of the things that you've been solved. But of course, one question that I have, as you said, the human rights, the international human rights bodies that get involved with the war and actions. And such instances, like, for this type of, like, minority, grassroots level issues, should be also be, looked into by the international bodies. So what is the enforcement? Basically, like, the support from internationals.
I'm sorry to interrupt you there. Could you take me through that slowly? Through this online thingy, it takes time to reach me. Yes.
So what I ask you is very simple. Now you said now the international bodies are getting involved. With like let's say for like international wars and stuff like that. So as you said, the basic human rights has to be created by like respectively of what and where and for who, right? So when this type of issue comes in a country like tier 3 country like Sri Lanka and the other suburbs, right? So what is the the support they can actually give it for to overcome these type of issues, the people who don't know what it's for.
Do you mean the people or the institutions that they look into through this?
I'm talking about international bodies,
international bodies, yeah. Okay, so first and foremost, I would like to take you through that. Even though those international bodies, they are involved in helping out and de-escalating the issues throughout the entire session, they cannot be directly involved into a sovereignty. That's where the state sovereignty comes into effect. So just for example, you can take the escalating or the issues that has been taken through, which has been happening through in the Sri Lanka. So even though there's been, there can be parties which say, yes, there's been breaches and complications on human rights, but even though they say that they can prove it and they have the evidence and throughout, so they can only take it to the international body, and international body has a certain limitation upon which they can act upon. So just let's for example, they can instruct and they can guide through the state sovereignty or states which they were involved in certain breaches. They can guide through them, and they can't go for a war with another state. The body which governs or which overlooks the peace, they can't go for a war, or they cannot discriminate any other bodies as well. So what they would do over here is they would advise, they would provide guidelines or guides, and they would advise them to take a righteous path following the basic basic contents of the United Nations Charter, if you would look into the certain parts of it. So upon when they fail to do so, then comes the consequence of the veto power countries which they would act upon, which complies the nations which they were told to act upon accordingly. if failing to do so, that would result in certain economical issues, economical complications, and so and so. So I hope I could answer your question.
Yes, very much. Thank you so much.
Thank you.
We have a question from the panel.
Okay.
This is maybe a controversial question, but during the 1990s there was a theory of the right to protect in terms of humanitarian intervention. Obviously, states can humanitarianly intervene under Chapter 7 of the United Nations Security Council under the Charter. Chapter 7 under the Charter, you can make a humanitarian intervention if you get the support of the Security Council. Now, as you know, there's what is known as rivalry between the United States of America and Russia, and sometimes the Security Council is stymied. For example, in 1999, during the Bosnian crisis, when the US and the UK took action to protect Kosovan Muslims, without official backing from the UN Security Council. My question to you is this: do you ever think there is a situation where humanitarian intervention can be taken even if you don't have the backing of the UN Security Council under Chapter 7?
Okay. So to make that question clear, let me repeat that in my terms. Please correct that if it's on the right path. Okay. Yeah, like it's according to the Chapter 7. Does the interventions or any other escalations can they be overlooked and taken care of without the influence of the United Nations and its charter according to Chapter 7? Is that so?
What I'm asking is that clearly you can take intervention under Chapter 7 of the UN Security Council. Clearly you can do that. There's no question about that under international law. If you get the support of the Security Council, you can take into humanitarian intervention. However, there are times when, because of big power rivalries, the Security Council is stymied, and yet there is maybe a humanitarian crisis which needs a military intervention. And I'm just asking you whether you can foresee a situation where you would support humanitarian intervention even without the backing of the UN Security Council.
Okay. Yes. Yes. According to Chapter 7, just like you did mention, when there's an act of aggravation, the Security Council they may put forward recommendations calling upon the parties to comply. So, but just like that, let's say in future, when the veto part countries, when they have an act of aggression, so there can be escalations there that can be detrimental to the basic charter when an escalation rises into a humanitarian crisis. Okay, I hope I just answered a bit of that. Is that does that comply?
We can move on, but it wasn't really the answer to the question. And also, under the UN Charter, under Chapter 7, if there's a humanitarian intervention can be defined as a threat to international peace and security, as well as obviously you mentioned active aggression. But what I was trying to get, there may be certain situations whereby there is a serious humanitarian crisis in the country, which does maybe require military intervention even without the backing of the UN Security Council, as was the case in Kosovo in 1999. But anyway, thank you very much for your contribution. I found your presentation very interesting.
Thank you. Thank you for your time too.
He didn't understand the question properly.
Okay.
He got into
So
the
this brings us
section
to
again. Charter.
Session 2. So we distributed the certificate to Ms. Dinusha Jeevaratne. I kindly invite Dr. Chairman of ID Nations Campus, Dr. Janagani, to give a certificate.
So
That's a big clap.
Yeah, we need to encourage it.
Yes, she was.
So that was the session was conducted physically. So online participants will receive their certificates later on at a later stage. So thank you everyone for attending to the